Commercial Division, original site. Item number 1 for judgment, Radha Bhatta versus Rashmi Cement.
This court is therefore of the view that Article 215 of the Constitution can be invoked for exercising the power to review the judgment passed by this court on 26 June 2023. The High Court, in exercise of its plenary powers, cannot be fettered by the limitations of the 1996 Act in respect of review, or be hemmed in by the strictures of Order 47 Rule 1 of the Code of Civil Procedure at the stage of allowing the application to enter through the gates. The first, that is invocation of the powers under Article 215 of the Constitution, is a question of maintainability, which is answered in the affirmative. The second, that is Order 47 Rule 1 of the Code of Civil Procedure, is a question on merits, which will determine the reviewability of the order within the contours of Order 47 Rule 1 of the Code of Civil Procedure. The court is therefore of the view that the present application succeeds in clearing the threshold test and entering the arena of review. The court will consider whether the application succeeds on the merits and the tests of Order 47 Rule 1 once a matter is taken up for hearing. RBW 34 of 2023 is therefore held to be maintainable. The parties shall be at liberty of mentioning the matter for hearing at an early date.
Item number 2, Say Equipment Finance versus Our Seeker Realty.
Yes.
Item number 2, Say Equipment Finance.
Having considered the relevant facts and the law on the subject, this court is of the view that the petitioner is entitled to an order of injunction, restraining the respondent from dealing with any further or creating any interest over the 13 flats, etc., in the building to be constructed by the respondent, in the building constructed by the respondent. Mr. So-and-so of the Bar Library Club is appointed as a receiver to take symbolic possession of the aforesaid properties, either by himself or through an agent as may be practical. The remuneration of blank of the learned receiver shall be borne by the petitioner together with all his travel, accommodation, and other expenses. The petitioner shall also make payment and other arrangements for the agent if appointed by the learned receiver in the event the receiver seeks to act through an agent. Since the parties have been heard at length, nothing further remains to be decided in the application. Needless to say, the parties shall act in terms of the mandate of Section 9(2) of the Act and the time frame envisaged therein. AP 387 of 2023 is accordingly allowed and disposed of in terms of this judgment. Yes.
Item 3, Poonawalla FinCorp.
Item 3, my lord, I am appearing on behalf of award holder in this matter. I am instruction to withdraw this application, my lord. I am praying the warrant is there, warrant should be discharged.
How many warrants are there?
There are two warrants, my lord. Warrant is par against the 1 and 2. Both. The warrants should be discharged.
The advocate on record of the petitioner / award holder seeks to withdraw the execution case. Stop. EC 358 of 2021 is accordingly dismissed as withdrawn. Stop. Interim orders, if any, shall stand vacated, and warrants of arrest shall stand discharged.
Good.
Warrants. Abhinav.
Grateful.
Item number 4, MSTC Limited.
My lord, I had mentioned the matter yesterday, my lord.
Microphone, please, Mr. Mitra.
My lord, I had mentioned the matter yesterday, my lord, on in view of the minor accident which the advocate on record has suffered. And my lord,
The examination of judgment letter. You're for the decree holder. Change sides. I have a problem in my
sorry,
brain. I can't
no, I'm
process.
so sorry, my lord. I should have noticed. I'm very sorry. My lord, may I seek your lordship's indulgence to keep it on the week after the 8th, even though I know the lordship had said 8th, but major injury suffered, my lord.
Learned counsel appearing for the judgment debtor. Award debtor. Submits that the award debtor number,
My lord, awarded, it's a company, the director, my lord.
that the director of the award debtor, who was to depose today, has met with an accident.
My lord, the advocate on record of the award debtors met with the accident.
Ki bola? Submits that the that the advocate on record of the award debtor has met with an accident and stop. Counsel hence seeks an adjournment. Stop. Advocate on record is based where?
In Calcutta, my lord.
So then why can't the award debtor come?
My lord, I'll tell you, lordship, certain documents have been sought for. Those, my lord, have to be given by the advocate on record, through the advocate on record, my lord. That's the reason, my lord, why. Plus, my lord, the award debtor, I'm told, my lord, the person deposing on behalf of the award debtor, my lord, is also, my lord, down with some viral fever, which is why, my lord,
Yes, seeks an adjournment on this ground. Stop. Next, list this matter on 22nd September.
I'm very grateful.
Microphone, please.
Lordship, any other day instead of 22nd September.
29th September 2023 as prayed for.
I'm very grateful.
As prayed for, also on behalf of the award holder.
I'm deeply obliged, deeply obliged.
Mark Hotels, item number 5.
This had been mentioned by me yesterday for correction of an order, my lord. I just hand out the
Yes.
correction, only small typographical mistake.
Are you mentioned, you're for the respondent?
Lordship, only one change.
Yes, you're the counsel.
Yes, sir. No, I'm the advocate on record.
The advocate on, this matter has been brought to the list at the instance of the petitioner, at the instance of the award holder. Stop. Next, the advocate on record of the award holder submits that the second page of the order dated 10th August 2023 should be corrected in the manner as follows. Stop. Next, the third paragraph at page 2 of the order should read as quotation marks, learned counsel appearing for the award debtor, ... Supreme Court of India, close brackets, quotation, Supreme Court of India, close quotation marks. Stop. Next, let the correction be incorporated in the order dated 10th August 2023 and be treated as part thereof. They can. Next.
Six, Poonawalla FinCorp.
Item 6, my lord, I'm appearing on behalf of award holder. I have instruction to withdraw this application, my lord, and also paying the warrants issued against 1 and 2 should be discharged.
Why are you withdrawing all your matters?
But they have
Today is
paid,
not the first time.
not first time, my lord. They have
Every
paid
time you
the,
come and withdraw all the matters, what is the problem?
no, in not all matter, but in the matter where they have paid the amount, my lord, I have instruction to withdraw.
Yes, same order as in Which one was the other
Number
one?
3, item number 3.
As in item number 3.
Great.
How many warrants of arrest?
There is 2, my lord, 1 and 2.
Two warrants of arrest. Next.
Item number 7, Kotak Mahindra.
Lordship, I am appearing for the award holder. Lordship, the matter has been settled between the parties. I wish to withdraw the warrant against judgment debtor number 1 has to be recalled.
Yes, the advocate on record of the petitioner submits that the dispute has been settled between the parties. Stop. She hence seeks to withdraw the execution case. Stop. EC 292 of 2022 is accordingly dismissed as withdrawn. Interim orders, if any, shall stand vacated. And how many warrants you said?
1.
And the warrant of arrest discharged.
Item number 8, Sumit Digital Infrastructure.
And for the respondent, Burmani Lordship, my lord. My lord, I filed an application for vacating of interim order, my lord, and that was taken up by Lordship.
Speak clearly into the microphone.
My lord, I have filed an application for vacating interim order that was taken up by His Lordship, the Honorable Justice Shekhar B. Sraf, my lord. On that day, my lord, since
At my instance.
yes, my lord, on that day, my lord, since my client is
What is it that you want?
at least, my lord, I am filing the application. I have affirmed yesterday, my lord.
File it. What stops you?
My-
File it, but then don't disturb the court. Yes,
My lord, I had
this
mentioned
was
this at-
mentioned for
yesterday.
discussion. Then
I mentioned, my lord, for extension of interim order. The interim order is expiring on 31st of August 2023. Lordship was kind enough to, my lord, include it as, my lord, to be mentioned today.
show me the interim order, please. 31st August.
Yes, my lord, the first order by which the interim order was granted is 8 July 2022. My lord, I hand up a copy, my lord.
No, I have it. Yes, then
My lord, the arbitration proceeding was stayed, my lord, on a section 14 application, which was initiated, my lord, without any notice and unilateral appointment. Then, my lord, this order was extended lastly on 8th of May 2023 till 31st of August 2023 by Justice Saraf. Lordship, I have a copy if Lordship wants.
no, I have it.
And thereafter, Lordship had the occasion to, my lord, hear the my lord, application once, and Lordship felt since there was a recalling and or vacating application, it should go before Justice Saraf. Now, when this application was listed before Justice Saraf, the respondent, who was, my lord, the applicant in the vacating application, did not appear. It was dismissed. So my AP survives, my lord. I am only seeking extension of the order in the AP, which is still, my lord, which was still 31st August. That's yesterday.
Yes, so AP is for is a 36-2.
AP is a section 14 application, my
14.
lord, under the Arbitration and Conciliation Act.
Very. So what was the interim order in terms of Pre B?
My lord, it was to stay the further proceedings in the arbitral reference, my lord. 8th of July 2022, my lord, order.
Very well. And what is it that you want?
My lord, since I have filed application for vacating that interim order, my lord, that is subject to Lordship pleasure, my lord.
But that interim order is of 8 July
my
2022.
lord.
You want to complete it, you've completed an anniversary after that. What steps have you taken?
My lord, actually, being a senior citizen, my lord, he is unable to, he don't have access to my lord, internet. Due to that reason, he missed, my lord. And due to that reason, at least
Very well.
we will
Yes,
be given a
you file it at your own time, in your own time, we shall see. This matter has been brought to the list at the instance of the petitioner in AP 502 of 2022. Stop. Learned counsel opinion for the petitioner seeks extension of an interim order dated 8th July 2022, which was passed by a coordinate bench and thereafter extended on 8th May 2023. Stop. The interim order is due, the interim order has already expired. The interim order expired yesterday. Stop. Next, the interim order is extended till 22nd November 2023. What is the holiday on the 21st for?
First is what? Jagadharti Puja, my lord.
Jagodharti.
Jagadharti Puja.
Very well. Till 22nd November 2023. Stop. Next, you're the advocate on record.
No, Mr. I'm the counsel. Mr. Maiti is there, my lord. He is on his legs, my lord.
Are you the advocate on record or counsel?
I am counsel, my lord.
Sorry. Next, learned counsel appearing for the respondent submits that the respondent has filed an application for vacating the interim order dated 8th July 2022, stop. However, comma, since the said application is not in the list, comma, the court does not wish to make any comment thereon.
Is it my lord's pleasure to, my lord, fix, my lord, hearing of this application, my lord? Because
Tell me
affidavits.
when. Tell me
My
when.
lord, I can, my lord, September, any date convenient to, my lord, I can do it, my lord.
List this matter on 25th September 2023.
Grateful, my lord.
Item 9, Ugro Capital versus Soba Hypermart.
Lordship, I am appearing for the petitioner. Lordship, the matter has been settled between the parties. I wish to withdraw.
Same order as in?
Lordship, item number 7 was an execution application.
Yes. The advocate on record, the petitioner submits that this is section 9,
Lordship,
that the application, that the dispute has been settled between the parties and hence seeks to withdraw the application filed under section 9 of the 1996 Act. Stop. Next, AP 503 of 2023 is accordingly dismissed as withdrawn. Interim orders of any shall stand vacant.
okay.
Item number 10, SK International versus Apricot Food Product.
Your Lordship, I'm for the petitioner. Your Lordship, I'm seeking an adjournment because the council appearing this matter is not available today and the services is not also completed.
Who is the counsel?
Duty my pal.
Have you not served? It's not
We have
complete.
already, yet it's not completed.
You're the counsel.
No, I'm the junior of the
Very
advocate.
well. Learned counsel appearing for the petitioner seeks an adjournment on the ground that service is yet to be completed. Stop. When do you want to come back?
On Tuesday,
List this matter on 5th September 2023 as prayed for. Next.
Eleven, Skyscrapers
This
Township.
is my
Management.
application, my lord. And yesterday leave had been taken from your lordship for moving it ex parte, but it appears that, my lord, the other side has already put in a caveat, my lord. We have served and we are moving it, my lord.
So ex parte. So Mr. Mitra is appearing for who?
And he is appearing for the respondent, my lord. He's put in a caveat.
Caveat. So it's a section 9.
It's a section 9, my lord. My lord, we have served, my lord. Section 9.
What was the urgency shown to the court?
Yes,
Mr.
madam.
Ray, you did not mention. Mr. Ghosh mentioned, yes. What was the urgency shown to the court?
It was the disconnection of electricity.
Yes, yes, yes.
My lord,
And the termination?
yes, my lord.
Yes.
Third termination, my lord. They have made a third termination.
Mr. Ray,
Termination.
microphone, please.
I'm sorry, my lord.
Yes.
My lord, this, my lord, my lord,
And who are you?
my lord, I am for the contractor developer, my lord. My lord, what is happening,
What
my
are you
lord?
developing?
My lord, 2 blocks in a gated community complex, my lord, in Sirampur.
Not a
developer
contract.
But why do you call yourself skyscrapers and not skyscrapers? Look at the cost
My lord,
title,
we have been
please.
scrapped. I believe that is why, my lord.
Look at the cost title. Is that a mistake?
That's how it is, my lord.
Skyscrapers. You deserve to be terminated on this ground alone.
Admission, my lord, Auditor Rule 6.
You don't know your client doesn't know the difference. Skyscrapers.
My lord, maybe for IPR purposes, my lord, could be.
IPR purposes. Very, very new explanation. Yes.
My lord, what has happened here, my lord? Excuse me.
Yes.
My lord, there was an agreement, my lord, for my lord, putting up 3 blocks, my lord, as a matter of fact, in this, my lord, complex, my lord. The blocks were G+12 with,
1 minute. Let me just see what interim orders, page 26.
my lord, I'm wanting, my lord, that they have said, my lord, I will just short it down. Third termination notice issued on 8th of August. I have received on 10th of August. They were supposed to give 15 days notice, my lord. It expires on 25th. I immediately give a letter that you cannot terminate because I have completed 92%. There were problems from your side. You did not given me materials. You have not given me proper substances which are supposed to be given under the contract.
So why have they not given effect to the first 2 termination notices?
Yes, that is the point, my lord. Every time, my lord, they give termination, They concede that no, there's no problem with us, no imposition of liquidated damages also. Now, my lord,
Contract provides for it.
yes, it provides for it. And my lord, all these documents, my lord, on termination, my lord, does not give a fresh end date. It says that expedite.
Does not give an end date for?
Because my lord, initial end date, there's a time fixed for the milestones. Afterwards, when they give a termination notice, they say we are terminating. And then we go up to them and they accept that they will not terminate, we are allowed to continue. But the termination notice, obviously, my lord, when an extension is given, they do not give a further timeline. So, my lord, under the laws, my lord, there wouldn't be a second time wouldn't be an essence of the contract if you don't give a second timeline.
Mr. Ray, I thought, Mr. Ghosh, did you not mention that the electricity was disconnected not by a state entity?
No.
When you mentioned the matter? No. You mentioned the respondent disconnected.
Responded.
But state is not a party, my lord.
No, my mistake. I probably assumed that it was WBSCDCL. And Mr. Ray, one thing, this respondent,
My lord.
what do you think? Any person known to the court?
I'm not aware, my lord, because these are litigating, my lord, companies, because I have also appeared for them, my lord. They were one company, then they broke up, my lord. If your lordship is, they broke up. This is the second part, my lord. This is the Sachin, the Rai part, my lord. If your lordship is wanting to know.
Yes, I will release it. The other party stays in the US.
Yes, my lord.
Yes.
But this company is totally different now. That has happened long time back, my
No,
lord.
but the other party stays in the US.
Yes, my lord. That party is not connected with this.
What?
This is a completely different company, my lord. One point
With
also
a
together.
sister.
Yes, my lord. They are no more in this
Yes,
company, my lord.
Yes. Yes.
Sister is here, my lord.
Yes.
The other partners company, my lord, if I may put
Yes.
it.
Since there is a chance, since the court feels that this matter is released from my list, stop. There may be an outside chance of one of the partners being known to the court. Of the respondent being known to the
Well, not a partnership, my lord. Your lordship will kindly correct.
one of the what is it, owners, proprietors,
I mean, can you, when
one of the proprietors of the respondent being known to the court.
Not in the right.
পাতাটাকে ছবি তুলে দিয়ে দিস
My lord, if your lordship will kindly.
Yes,
Let's
yes.
not take it before
Since next, the matter has been listed on the ground of urgency. The matter was mentioned yesterday and listed today on the ground of urgency. Stop. The petitioner / its advocate on record is hence given leave to approach the office of the Honorable the Chief Justice for urgent assignment. Anything else you want, Mr. Ray?
I think, my lord, now things have changed, my lord. My lord, it needs.
Because
to
Mr. Mitra is here.
No, my lord. My lord, for the assignment, my lord. My lord, it has to be, my lord, placed by your lordship's court before the department, before the.
Fine.
My lord, whatever the. Because now they are not accepting any letter, my lord.
Very well. তাহলে এই লাইনটা কেটে দাও। The parties are, the matter shall be sent
Yes, my lord.
to the department for urgent assignment.
In the meantime, if Mr. Mitra's client just holds his hand. I will hold his hand, my lord, kindly, my lord. My lord, because they are throwing us out, my lord. I am now in a complete, I don't know what to do. And I'm sure Mr. Mitra is here. If he just says once.
হয়ে গেছে তো
No, my lord, I'm not ousted. I'm in the.
I am ready to argue.
My lord, then, my lord, kindly reconsider, my lord. This person is no more in the. My lord, it's a completely separate company.
I will tell your lordship only one thing, only one thing. He has received GST from me
has not deposited GST of approximately 70 lakhs of rupees. Suppressed completely.
No.
in the
Mr.
petition.
Mitro, you may have a very good case. All right, I wish I could take up this matter. You may have a very good case on what you are saying. And if it's coming from you, I have no doubt about it. But
So it's,
Mr. Mitro, if the agreement provides for a notice, you will have to abide by that.
I have done that. I've done that.
Very well. That's what Mr. Ray said, that you have not done that.
No, no, no. They have responded to it. There has
The
been a
point is, what Mr.
rejoinder to
Mitchell
it.
is saying today, my lord, that is the arbitrable dispute. So that is why, my lord, it is, my lord, your lordship on last
Firstly, my
occasion,
lord-
Cosmic also, my lord, found that we have.
Mr.
I
Mitro,
know.
once I've released the matter, I don't want to, obviously, it's not right.
My
It's not right for the court, but Mr. Mitro, it is, I mean, how is the court interested? Can't be. But just a matter of propriety, that till the assignment is done and the matter is taken up,
Kindly
You should-
not
you
make
should-
any observation, madam.
I have not made
The
any
doc-
observations. The
The
order is done.
the documents annexed to the petition would show that, my lord, somebody else has been engaged. Yes.
No
Kind-
one named, my lord. This is not correct, my lord. No one named.
Kindly don't, my
In
lord,
2 days' time, my lord.
kindly don't make any observation.
No, I have not made any
Sir, It's from
observations.
Mr. Mitchell to.
এটাকে
এটা তোমাকে বললো, দাদা।
এখনই পাঠিয়ে দাও।
আমার proposition
তুমি
is
senior,
clear.
I am grateful.
হ্যাঁ, তাহলে বলে দাও ওনাকে বলে। ডিপার্টমেন্ট না করে বলে দাও সেক্রেটারিয়েট অফ দ্য চিফ জাস্টিস অফ দ্য অনারেবল দ্য চিফ জাস্টিস।
Item number 12, East India Minerals Limited, for the respondent number 1. There was a dispute that the
1
nomination.
minute.
Milord, and for the petitioner,
What is it? 9?
no, Milord, this is an application under section 14 and 15.
Okay.
Now, so there's a subsequent development. I'm sure my learned friend would want to, Milord.
14 and 15?
Yes.
So you want termination and substitution?
Milord, the learned arbitrator has himself, Milord, terminated. It should really be under 15.
Himself terminated?
Yes,
For what reason?
He's very old, Milord. He's sent. a
He's
letter.
very,
He's very old, Milord, very
Old.
aged gentleman, Milord. He said that it's no longer possible for him to continue with the arbitration. Now, subsequently, Milord, we requested for a reappointment. They did not within the required time. They said we want more time. They ultimately, having regard to their failure, we, Milord, filed this application under section 14 and 15. Now, this is not a case where the initial appointment was under section 11. So if there was an initial forfeiture, your lordship's
no,
judgment-
how was the appointment made then?
No, it was, we nominated, they nominated
Out
third
of court?
out of court.
One only thing is that, my lord, we have already,
Yes.
Now, judgment. Now, your lordship's judgment, my lord.
No, Mr. Chaudhary, don't show me my
Yes,
judgment
Milord, I
first,
just-
please.
I
Just tell me what you
Milord,
want.
please come to page 131.
Yes.
Milord, this is the learned arbitrator writing.
Yes.
I'm in receipt of your letter dated such and such, wherein you have stated that by an order dated such and such passed by the Honorable Justice Shekhar B. Saraf in such and such, the Honorable Court has appointed the former Honorable Judge of the Supreme Court, Justice Ashok Kumar Ganguly, as presiding arbitrator. I was further informed by you that I was acting as learned arbitrator nominated by the Odisha Mineral Development Company Limited, requested me to act and conduct the arbitral procedure. However, due to my acute ill health for reasonable time, it is not possible for me to act and appear and conduct as arbitrator on
So
behalf.
who, how was he, the parties agreed to his
Parties had
appointment?
agreed. And Milord, we had applied before court, and Milord, the learned presiding arbitrator was appointed. Now,
Presiding arbitrator.
yes,
So each party nominated their own.
nominated their own arbitrator. There was a third arbitrator. Third arbitrator wasn't there, Milord.
So in terms of a 21 notice,
Yes. And the
Sent by?
arbitration
you,
sent by me.
yes.
Us. Arbitration had started before a full arbitral tribunal was constituted. Milord, the respondent came and Milord said this arbitration should not continue because there are criminal proceedings against us. The arbitral tribunal, my lord, felt that yes, it should not continue because it has a bearing on the matter and refused to, my lord, have further sittings. We were ultimately discharged, my lord, from the criminal proceedings. Then, my lord, we wrote to the learned arbitral tribunal to continue the proceedings. By then, my lord, the learned arbitral tribunal wasn't really constituted because the presiding arbitrator was no more. Therefore, my lord, we had to come to court, and this order of 19th of May 23 was passed. Now, my lord, my learned friend's nominee arbitrator, after, my lord, being informed that the arbitration would continue again, expressed, my lord, his inability to act as an arbitrator any further, which is why he wrote this letter at page 131. So then, my lord, we requested him, the respondent to nominate an arbitrator. They did not do so within the required time. So we came to court.
No, so who expressed? The presiding arbitrator said he can't act.
No, no, no.
No, his nominee,
You have to wait. I will come to you. Yes,
his nominee arbitrator said
Very
that he
good.
could
Yes,
not
very
act. This is that letter at page 131.
yes.
So, my lord, we requested him to nominate again. He, my lord, didn't act within the required time. So we filed this application before your lordship. After service of the application, they nominated somebody. Principle is, my lord, once we come to court, after expiry of the time, it is your lordship's domain to appoint. This is the only thing. Now, while, my lord, getting ready for the matter, my lord,
So you're not happy with, first of all, they took, the respondent did not took time and then nominated somebody.
yes.
But you're saying that the respondent couldn't have done that because that was done after filing of the application.
Yes. Data switch gears judgment, my lord, applies. And the other judgment, my lord, which is relevant, perhaps I need to show this to your lordship, is your lordship's judgment. Which, my lord, perhaps applies when the initial appointment is under section 11. That is when, my lord, your lordship held, my lord, that if there is an initial forfeiture under section 11, in that case, ultimately, when you need to appoint, the original rules and procedure don't apply. And you have to.
I don't remember this matter. What was the?
No, I'll tell you. You know, it was section 14 application. You know, kindly come to paragraph 8. The petitioner had appointed a sole arbitrator. The respondent made a written request to the appointed arbitrator to withdraw on the ground of unilateral appointment, but was denied, which led to the respondent filing an application under section 14 for termination of mandate. Coordinate bench passed an order on 22nd February, noting that disputes had arisen and appointed an arbitrator on consent. The arbitrators thereafter communicated their inability to perform the functions on the ground of elevation to the bench and relocation outside India. There is no doubt that the arbitrators have become de jure and de facto unable to perform their functions under section 14. The inability to continue with the mandate is also under one or more of the grounds under section 15. Now the question is, who appoints, my lord, subsequently? And your lordship, my lord, ultimately after paragraph 16, what rules mean as, my lord, to be found in section 15 of the act is, my lord, after paragraph 16, my lord, paragraph 17 to 21. And then, my lord, after paragraph 21, it is party autonomy which takes a backseat once the court makes an appointment. And therefore, your lordship, my lord, ultimately was pleased to appoint an arbitrator, appoint 2 learned arbitrators. And it does, and your lordship held at paragraph 29 that the above discussion must and invariably tilt towards the court appointing new arbitrators in the same manner as was done on the previous occasion on 22nd February when the parties approached the court under section 14. There is no statutory basis.
Where are you? Which paragraph?
Paragraph 29.
29.
The above discussion must and invariably tilt towards the court appointing new arbitrators in the same manner as was done on the previous occasion on 22nd February 2022, when the parties approached the court under section 14 of the act. There is no statutory basis to send the parties back to the section 11.5 position. So, my lord, My understanding is that if there is an initial forfeiture of a right to appoint, then my lord, when there's a subsequent my lord vacancy, you don't go back, have to come to court.
But in that case, the parties were already before the court, before justice, before the
here-
coordinate bench.
So here, my lord, since the parties were not before court, the original rules and procedure under 11 would apply. In which case now section 15 would apply, which is why I requested them, my lord, to appoint, and they did not. And I filed the application. Once I filed the application, then, my lord, Data Switchgear's judgment would apply in full force. In Lord, 2000 volume 8 SCC, page 151. Paragraph 19 of this judgment, my lord, 18 and 19. If I may place, in the present case, the respondent made the appointment before the appellant filed the application under section 11, but the said appointment was made beyond 30 days. Question is whether in a case falling under 11.6, section 11.6, the opposite party cannot appoint an arbitrator after the expiry of 30 days from the date of demand. So far as cases falling under section 11.6 are concerned, such as the one before us, no time limit has been prescribed under the Act, whereas a period of 30 days has been prescribed under section 11.4 and 11.5 of the Act. In our view, therefore, so far as section 11.6 is concerned, if one party demands the opposite party to appoint an arbitrator and the opposite party does not make an appointment within 30 days of the demand, the right to appointment does not get automatically forfeited after the expiry of 30 days. If the opposite party makes an appointment even after 30 days of the demand, but before the first party has moved the court under section 11, that would be sufficient. In other words, in cases arising under section 11.6, if the opposite party has not made an appointment within 30 days of demand, the right to make appointment is not forfeited but continues. But an appointment has to be made before the former files the application under section 11 seeking appointment of an arbitrator. Only then the right of the opposite party ceases. We do not therefore agree with the observation in the above judgments that if appointment is not made within 30 days, the right to appoint an arbitrator under section 11.6 is forfeited. Now,
Mr. Chaudhary, sorry.
Yes, ma'am.
Paragraph 18 of this Datar,
Yes.
that is a 11.6 situation, all right?
Yes.
Why, how would you draw a link between Datar and whatever is before the court?
In view of the language of section 15 of the Act. Section 15, subsection 2. Where the mandate of an arbitrator terminates, a substitute arbitrator shall be appointed according to the rules that were applicable to the appointment of the arbitrator being replaced. So, my lord, the rules are, my lord, here it has to be section 11 rules. So therefore, my lord, this is the.
So here, if it is section 11 rules, then it is not what I held in the other one, the
That's why
judgment which you showed.
So therefore, my lord,
Because in that judgment which you showed, that judgment, my view was that since it was done under 14, at the stage of 14, and the arbitrators were appointed, and the parties have come to this court for substitution, then the court will not go back to 11, but will simply appoint from the stage. So what my view was that the 14th stage will continue. Parties will not be sent back to the 11th stage.
That's what the sum and substance is. If you once, my lord, fail to use party autonomy to appoint an arbitrator, you can never go back. That's your lordship's judgment. But
Yes.
in this case, my lord, there has been no failure before this. We've both, my lord, nominated before this. And
Yes, so then why do you want to go back to the 11th? Because I can understand Datar switch gears to the extent that the 30 days is not forfeited, but continues till an application is filed. But that is under 11.6 position, because 30 days is 11.5. All right. But here you're coming in a 14 situation and saying that you want termination, you want substitution rather, because no appointment was made before filing of the application, and the respondent appointed only after filing of the application. Therefore, the parties surrender their right to appoint once an application has been filed.
Your Lordship is right. Because even after the learned arbitrator's letter, my lord, we, my lord, need a section 14 order. So once you go to 14, then there's no going back to 11. Your Lordship is right. But so therefore, my lord, kindly, my lord.
So Lordship is right. So therefore, what does it mean?
My lord,
So then what happens to the first limb of your arguments?
My lord, it's that's why, my lord, I wasn't very sure, my lord, on this. So whichever view your
No,
lordship.
no, neither is the court. It's just because a court delivers a judgment doesn't mean that the court is absolutely sure of the law. It may be set aside by the division bench.
Really speaking, whichever way one looks at it, your lordship's view is followed, which is, my lord, a binding view, because it hasn't been set aside. Once 14 comes in, then there's no going back. So even then it's to be a court appointment. If one doesn't follow that view and goes back to, my lord, 11, even then he's lost his right, my lord, because I filed the application before he nominated.
So,
So
Mr.
therefore-
Chaudhary, you will just have to fill in one, you just have to draw one link. That is the loss of a party's right to appoint an arbitrator once an application has been filed under 11.6. That analogy will also bind, or that analogy will continue where it is also an application under 14. Understood? So data switch gears will also apply to a 14 situation.
Yes, but the question your lordship asked me that, how do you take this judgment back to section 11? For that, my lord, section 15 subsection 2. So even if, my lord, this, your lordship's judgment, your lordship is not, my lord, following the principle, and my lord feels that it's my lord, party autonomy still exists. Even then under section 15.2, because of section 15.2, when such a situation arises, party nominates, he is entitled to nominate within 30 days or till the time I file an application, because original rules apply. Rules would mean I nominate, he nominates, etc.
So
And
original
failure is 11.
15.2.
15.2 takes us back to 11. 11 says that if you're entitled to nominate and he's entitled to concur to my, I'm entitled to concur. Oh, I'm sorry, Milord, it's a 3-member arbitral tribunal. So he's entitled to nominate his nominee. But once he fails to do that, and once I file, then using data switchgear, he loses his right.
Very well. Yes. What do you have to say?
Well, first of all, my lord, we have not refused.
Microphone, please.
We have not refused any person to be nominated as our arbitrator. There was a little delay due to procedural lacuna.
No. Did you nominate after filing of the application or before?
After the application is filed, my lord, we have got the instruction from this is the central government undertaking, and mines were already not in operation for long back. And such being the situation, they could not promptly act. And after all, we have.
It's a point of law.
Yes.
It's a point of law.
After all, we have only thing I can say, my learned friend is relying upon section 11, and it's a clear cut and settled provision of law. It is an appointment under section 15.2 of the Act. So if it is an appointment of the 15.2 of the Act, they have to say that we have refused. Actually, our case is that there is a clear distinction in this by the Supreme Court judgment between the withdrawals and the refusal. In our case,
What did you withdraw?
our case, our nominated arbitrator, he has withdraws because of the age ailment that he cannot function, and he informed us. We have already received information from our department that that person, Mr.
That
Suresh
is
Chandra
not, none of this is in dispute.
Yes.
The
So-
only factual question is whether you have nominated after filing of the application
Yes,
or before.
yes, after filing of the application, we have got instruction. And thereafter informed, and we have informed the presiding
So
arbitrator.
that is all right. The court will
So,
appoint. The court
yes.
will appoint an arbitrator.
Arbitrator, if the court thinks so, anybody can be appointed.
So then,
So-
I will not go into all this law.
But-
I'm tired of all this.
But one thing I must point out, your lordship's own judgment rather refers the autonomy of the parties. Paragraph 23 of your lordship's judgment says that the autonomy, the argument is based on the reference of the parties' autonomy in the 1996 Act. where the court's intervention in the matter of choice in the arbitral process is especially curtailed under section 5 of the act. Section 5 declares that a judicial authority shall not intervene in the matter governed by part 1 of 1996 act except where the act permits intervention and regardless of any other law for the time being in force. The argument is also based on the difference between the section 14 and 15 and 11 of the act, where the power of the appointment of an arbitrator by the High Court is reserved only in section 11(6) of the arbitration, which are not international commercial arbitrators. So, your lordship upheld the autonomy. There is no clause in the arbitration agreement in the event of the death or in the event of the substitution of the existing arbitrators on the ground of refusal or
Anyway,
withdrawal.
I will nominate somebody.
Yes, whatever your lordship will pass the
What
order.
is the person who has withdrawn?
The
He is,
person,
he was, what?
Advocate,
the senior advocate of this
Advocate.
court.
Mr. Arvind Das.
Yes. What is the value of the claim? And who is the presiding arbitrator?
Justice Ashok Kumar Ganguly. This claim for specific performance of an agreement.
What is the value?
Substantially high, my lord. Substantially high, my lord.
No, I will
Not-
just nominate somebody.
Yes, my lord. I am not certain of the value, my lord. But it's a heavy claim that regarding, my lord, a mining lease. It's a heavy claim.
Organization is, my lord, suffering financial crunch long back. Our organization, central government undertaking, mines are not in operation. Kindly consider that aspect also.
And what? And do what?
Nothing else. Your lordship kindly, as a matter of fact. what
Yes,
is-
this is an application under section 15 of the 1996 Act for appointment of the respondents, apostrophe S, respondents nominee arbitrator in terms of the arbitration agreement, in terms of an arbitration agreement dated 4th October 1993. Stop. Next, the undisputed case is that there is already an arbitral tribunal in place consisting of 2 nominee arbitrators and 1 presiding arbitrator. The tribunal was constituted on
I'm sorry. At the first 11 June 2023 after reconstitution. my lord, by
11th June 2023. Stop. The respondents nominee, however, Mr. Chaudhary, are you sure? Because from within 8 days, the nominee arbitrator of the respondent said, I can't do it.
This is after Justice Saraf's order. The initial reconstitution is
No,
31st
no,
August
he bola,
2007.
11 June 2023 pursuant to an order passed by a coordinate bench on 19th May 2023. Stop. The respondent's nominee arbitrator, however, expressed his inability to continue with the matter by way of on the ground of ill health, and communicated his decision to retire from the matter, from the arbitration by way of a letter
19 June 2020.
dated 19 June 2023. Who is Haricharan Yadav?
Lord, my learned friends,
Very well.
advocate on record.
2023. Stop. Next, the only question before the court is whether, at a line at Koro. Next paragraph. The learned counsel appearing for the petitioner submits that the petitioner wrote to the respondent to nominate its arbitrator after the letter of the erstwhile arbitrator of 19 June 2023, but the respondent failed to do so and only took steps to nominate its arbitrator after filing of the present application. Stop. When did you nominate, Mr.
30th August 2023.
The respondent nominated its arbitrator on 30th August
Sorry,
2023.
my mistake, Lord, it should be 29th August.
29th August 2023, whereas the present application was filed on 17th August 2023. Stop. Next, the only question before the court is whether the respondent, whether the respondent's nomination is relinquished, stands relinquished in favor of the court's nomination after filing of the application. Stop. Next, in Tata Switchgears versus Tata Finance 2008 SCC 151, comma, the Supreme Court held that the right to nominate an arbitrator under section, that the right to appoint an arbitrator within 30 days from the letter of demand under section 11 within brackets 5 and 6, comma, the right is not forfeited but continues until the other party files an application for appointment of an arbitrator under section 11 of the 1996 Act. Stop. Although, comma, the present case is although the present application is under section 15 of the 1996 Act, namely, comma, substitution, namely, comma, termination of mandate and substitution of arbitrator, comma, the subsection 2 within brackets of section 15 assumes importance. Stop. Section 15 within brackets 2, although theke pore paragraph polo. Section 15 within brackets 2 provides that where the mandate of an arbitrator terminates, comma, a substitute arbitrator shall be appointed according to the rules that were applicable to the appointment of the arbitrator being replaced. Stop. It is arguable whether the parties will be relegated to the section 11 position on the respondent failing to appoint its nominee arbitrator before filing of the present application, colon, reference, Srey Equipment Finance versus Sera Infra Venture 2023 SCC Online Cal 2030. Stop. The decision of Srey, the decision in Srey was based on a different fact hyphen scenario where the arbitrators appointed by a coordinate bench were rendered de jure / de facto ineligible to perform their functions. And the court stepped in to nominate arbitrators in place and stead of the erstwhile arbitrators. Stop. Next, however, comma, if the principle in if the principle laid down by the Supreme Court in Tata Switchgears is followed, comma, it would together with the statutory framework of the 1996 Act, comma, it would be clear that party autonomy continues until the parties come to the court for appointment of an arbitrator. Stop. Once an application is made, comma, the court steps in to take over the right of appointment. Stop. Next. The learned counsel opinion for the respondent does not oppose the court's power to appoint, does not oppose appointment of its nominee arbitrator by the court, but argues that the decisions relied on by counsel appearing for the petitioner may not be applicable to the present case. Stop. Next. WPA, AP 558 of 2023 is accordingly allowed and disposed of by appointing blank to act as the, do you have any lawyers in mind? No. By appointing blank to act as the nominee arbitrator, to act as a nominee arbitrator of the respondent on the same terms and conditions as the erstwhile arbitrator. Everything, the remuneration, everything was fixed, of the fees as the erstwhile arbitrator. Stop. The proceedings will continue from, there shall be no interruption in the proceedings as mandated under section 15 of the 1996 Act. Stop.
Item number 13, Steel Authority of India. May it please your lordship, my lord, I appear for the applicant in this application, my lord. The main AP is a section 34 application filed by my learned friend's client, my lord.
Lordship, I appear on behalf of the petition in the section 34 application.
My lord,
What is the GA1 for?
my lord, GA1 is, my lord, I'm seeking a clarification from your lordship's court
Yes.
that there is no embargo in my proceeding before the West Bengal Micro Small Enterprises Facilitation Council for my claim of interest, my lord.
You're the,
I was the claimant supplier, my lord.
where is the 11 June order?
I'm sorry, my lord.
What is the clarification you want? Where is the order?
My lord, there is no order, my lord. What has happened is, my lord,
You're saying dated 11 June 2022, Prairie. Look at your Prairie.
my lord, this is the 11 June. My lord, we have made an application on 11th of June 2022 before the Facilitation Council, my lord.
Yes.
My lord, may I just place the small facts of the case, my lord?
No, I don't understand. There's a 34 pending.
Yes, there's a 34 pending. They are
Okay.
saying that since there's a 34 pending, I cannot claim the Facilitation Council should not proceed with my claim for the interest under the MSME Act.
No, the award did not take account of the interest.
No,
Did
my
not.
lord,
And have you paid the 75%?
no, my lord, they have paid me the entirety before they filed that 34.
Please, Mr. Gupta, this is a point of law.
Lord.
I'm talking about section 19 of the Act.
Yes,
Don't
ma'am.
go on the facts.
No,
Have
my
you
lord.
paid the
They
75%?
paid the entirety of the awarded sum to me before they filed their section 34.
Not only one thing, this section 19 is
No,
possibly not applicable here.
1 minute, please. Whether they paid to you is a matter of the proviso of under section 19 or 19(1), whatever it is, which says that the supplier can make an application for withdrawal of the 75%.
Yes.
Then what happened? in the
Your
my
law?
lord,
lord.
will kindly give
What-
me a minute, my lord. Kindly, my lord.
May I just? Award made, they paid that entire awarded sum to me.
Yes.
After paying that, there was the award says that I am not entitled to claim interest. If I am to claim interest, I have to go to the facilitation council.
The award says that.
The award says that. So I approached the facilitation council on 11th of June 2022. After I approached the facilitation council, my lord, they have filed this section 34.
Yes.
Now, I wanted my claim for the interest to proceed before the facilitation council, my lord. They have written to the facilitation council that since there is a section 34 pending, please do not proceed. And since then, the facilitation council has not proceeded. So my prayer,
From July 2022.
my lord, may I just place that letter of my learned friend's client, which says that
I'm just asking you a factual question. Since when has the council not proceeded?
my lord, last we were asked to file our statement of claim over there, my lord, in September 24, 2022. 24th September 2022, we were asked to place our documents and the claim before the facilitation council by the facilitation council, which we did.
Can't you understand the court's question?
Since then, it has not.
Since when has the proceedings been stalled? That's all.
My lord, September 2022.
Yes.
But may I indicate one
Yes.
thing? This is not an award by the facilitation council. It's an award other than by.
Other than.
Yes, but it's an award by an
Under
arbitrator.
18.3.
No, it's not an MSME award at all. It's not an MSME award. It's an award passed by Honorable Justice Tapan Kumar Datta retired. But in that award, the London arbitrator did not award any interest. What we did.
No, then where is the facilitation?
I'll just indicate.
Yes.
The award did not grant any interest. What they did was, as in the petitioner before your lordship, they filed a fresh proceeding before the MSME facilitation council only for the interest component. That is yet to be decided. Now, before filing the section 34 application assailing the award, my clients, which is the petitioner in the section.
So why did you pay the entire awarded amount to the respondent?
Without prejudice to our rights and so that the interest does not start running.
And without an order of court?
Without an order of court before the filing of the section 30. So that there's a stay on the award and so that the interest does not mount. So without prejudice, my clients have paid that.
So the interest component is not part of the awarded
Interest
amount.
component is not part of the award.
Then what is the problem if they go to the council?
Because the entire award is lying stayed now, as per the section 34, the
award is without the interest.
Award is without interest. The award, the principal amount, whatever has been awarded is lying stayed.
Yes.
Once we have secured the money.
So you fight that out, the principal amount. But what did the award say about interest?
The award did not grant any interest.
Page 42.
Did the award say that they would be entitled to go for that interest before the facilitation council?
Page 42, may I read it for your lordship? Lord, it will appear from section 18 of the said MSMED Act that any party to any.
Show me the last page of the award, please, first.
Lord, last page of the award, my lord. Your lordship will find at page
45.
Yes, where does it say that interest claims will be before the council?
Page 42, my lord. Paragraph 31, subparagraph B. It will appear from section 18 of the MSMED Act that any party to a dispute may, with regard to any amount due under section 17, make a reference to the MSME Facilitation Council. It is argued on behalf of the claimant that the word may.
Who was the claimant?
I was the claimant.
Yes.
Claimant that the word may in section 18 indicates that the reference to the Facilitation Council is optional. This tribunal is of the view that the word may in the said section 18 indicates that it may be optional for a party to claim interest. But if the party decides to claim interest under the MSMED Act, then the party has to approach the appropriate forum, that is the Facilitation Council, as mentioned in the special provisions of the MSMED Act. So, my lord, pursuant to that, I have approached the Facilitation Council for the claim of my interest.
What is the date of the award?
The date of the award is 11th of December 2021. Your lordship will find it at page 12.
Yes.
And then, my lord, there was a section 33 by them, which was,
And where does it say that I am not granting any interest to you? That is that same paragraph.
yes, my lord. In the present case, the claimant has claimed interest under the MSMED Act, and as such, the special provisions made for reference to the Restoration Council cannot be ignored and or bypassed. In such circumstances, the tribunal is not inclined to decide the question as to whether or not claimant is entitled to any interest under the provisions of MSMED Act.
Very well. Yes, yes, Mr. Gupta.
Yes, my lord, 3 points. My lord, first, I would like to use an affidavit, my lord, to bring on 2-3 facts. My lord, may I indicate? First is, this is not a case where the tribunal did not decide the interest and remanded the matter to the MSMED. Because my lord, what the tribunal was adjudicating is whether at the MSME rate, the claimant is entitled to interest because the claimant is MSME. On that issue, my lord, the paragraph at page 42 is there. The tribunal has awarded interest,
Yes.
which your lordship will find at page 45. The
But,
tribunal,
Mr. Gupta, I don't see any prejudice.
But
If the council allows interest, awards interest, you can always come before the
they
court.
can't, they cannot, in my humble understanding, which your lordship will kindly test it. The reason being, the jurisdiction of the facilitation council to award interest is only when a claim is lodged before the facilitation council. The claim was not lodged before the facilitation council. It was
So will
before
you not be able to contest and take that point before the council?
the other reason why I perhaps
So
may not.
take that point before the
Perhaps may
council.
not, because the award is lying stayed. So if the principal is lying stayed, once a section 34 is filed, the award is lying
Gupta,
stayed.
no, I'm not with you. If the interest does not form a part of the award, there is nothing to prevent the petitioner to go and you will contest that proceedings before the council. Take all these points before the council.
May I only try and impress upon your lordship on 2 legal points?
Yes, yes.
I'm not troubling your lordship with any other facts. But your lordship will kindly have a look at section 18 once of the micro, small, medium.
Mr. Gupta, you will try to impress upon the court that whether the council can at all entertain the claim or not of interest. I will not even go into that because that is the domain of the council. If it's like a 16, section 16. If the council, you will be there.
I understand. I'll not.
If you take up that point that the council cannot adjudicate, take up that point.
I completely bow down.
But
Not the
at
next
this
point.
stage,
I completely
at this
bow
stage,
down.
no.
But I'm not
Yes.
troubling your lordship with that.
Yes.
The second point is that the fulcrum of the claim for the interest is the award which has been passed in the favor of the my learned senior.
Yes.
So when that award is lying stayed before this honorable court, possibly the jurisdiction would not be there to proceed with that because it's a stay. Filing of a section 34 amounts to automatic stay. That was the law. Till BCCI Kochi came
No,
in
no, no.
and
Don't give
wanted,
me all those laws, please. Now, yes.
but the award is lying stayed. So they cannot claim as a matter of right interest on what is already stayed. We have secured the entire money prior to filing the 34. The entire money is the principal component which was awarded. We have paid them without prejudice to the 34. So once that has been done, and until such time the award is, the award may, your lordship may sustain the award, might set aside the award. So in that event, the jurisdiction to adjudicate on an interest, possibly subject to your lordship's understanding, and your lordship's interpretation, is possibly will not be there. That is my answer.
Very well. Yes, Mr. Gupta.
my lord, only thing is, my lord,
Microphone, please.
my lord, the only point is, my lord, they file a section 34 on 29th of June 2022.
Yes.
Their section 34 was filed on 29 June. My application before the Facilitation Council was on 11th of June 2022.
Yes.
Now, my lord, affidavits, directions for affidavits were made, my lord. Affidavits have been completed, but they have not taken any steps for having the 34 heard out. Now they are saying that because my section 34 is pending, the Facilitation Council should not proceed.
When was the award? When was the award stayed?
No, there was no stay of the award. My lord, the order of admitting section 34, your lordship will find at page 10.
The award is not stayed.
No, my lord. Page 10.
There was no requirement for any stay because we have secured the entire matter.
Page 10.
Yes. Anything else? Mr.
And my lord, so my lord, if your lordship sees my notice of motion, I have two prayers, alternative prayers. Either the facilitation council proceeds with my claim under for the interest, my lord. Alternatively, if your lordship holds that no,
Very well, I've understood. Mr. Gupta, only one thing, I will dictate the order next week, maybe Monday. Only one thing. What your second point, first point, I'm not with you. Your second point, arguable. You're saying that if the award itself, no formal order of stay, but in any case amounts to such because you've secured the entire amount. But that question of interest, the arbitrator, the learned arbitrator has said that I am not deciding that. So whether a point which is not decided in the award becomes part of the award.
I understand. I need to satisfy your lordship. I shall do some research and assess.
Because it is not that the learned arbitrator has held that I do not think that the petitioner is entitled or that I think the petitioner is entitled. The arbitrator has held that I am not inclined to go into it because I will not decide the question. Let the council do that. All right. Whether an issue not decided becomes part of an award.
Possibly the arbitrator has not gone in to say that let the council do that. That the arbitrator has not done, possibly, subject to your lordship.
Very well, very well. But no doubt that that issue was not decided.
Not decided. But I'll do some research and assist your lordship.
Yes, and no affidavits, please.
Very well.
Yes, because these, I will
I
stop,
understand.
I will stop giving directions for affidavits in all matters until and unless the parties show me that it's absolutely essential. Otherwise, matters just get stalled because of this. Yes, learned counsel appearing for the petitioner and the respondent will continue with their arguments on Monday.
Could I get some more time, my lord? On Wednesday, my lord.
You're speaking on your own behalf or Mr. Gupta?
both of us, both
Both Mr. Guptas are
both Mr.
ad
Guptas
item
are-
on that.
Yes, 6th September 2023 as paid for.
Great. Extremely.
Item number 14, food and public distribution.
My application.
Do you want to file an affidavit, Mr. Kothari?
Lordship, I want to, but what fell from your lordship on the last matter.
Think both of us heard that. I don't
I'll-
think affidavits will be required here. Well, it'll actually come down to two questions of law. One, slightly silly on my part to argue, but
It's
I still argue
34.
it.
34.
34. One very interesting point, and your lordship will to really decide that. Just one page 118. And I think your lordship will probably have to lay down the law on this. I'll just argue that, sorry, but then.
I'm very embarrassed about all these judgments. Yes, 118 is what? That's the award.
Yes, 13, but I won't sensationalize this. 118 kindly mark.
You sensationalized and you won, so that's fine.
But,
Yes.
118 is 13th April 2023. 118.
How many arbitrators?
One.
One.
This council, MSM, the council.
No, but 129 has so many signatures. What is-
118, you know. I'm,
No, I'm look at 129. Is it the last page of the award?
yes. This is the council. So all the members have signed.
Very well.
Five
Yes.
members.
Yes. You're the what buyer?
Buyer.
Yes.
Suit for price, essentially.
But 118, your lordship will just mark the date, 13/4/2023.
Why suit? It's a reference.
The reference. But
Yes.
as in section 55 of Sale of Goods Act.
Yes.
13/4/2023, please turn over, my lord. Page 119, top right-hand corner.
8/3/2022.
So 1 year, they keep it in the drawer. And a 27 lakh claim for principal has by MSME Act now become 1.05 crores.
No date or at page 129.
129 is
No
no,
date.
no. And one more thing, kindly turns over to 120. This is going to be what I'll argue. The dates of hearing.
Yes.
8/6/2018, 1/10/2018, 31/10/2019. Now, all this is before COVID. Then 11/1/21. So conciliation starts on 8th of June 2018 and ends on 11th January 2021. Arbitration starts on 16th December 2021 and then 8th March 2022. Well, this, in my respectful submission, is contrary to section 18 of the Act, which says the entire reference will have to be within 90 days.
No, I don't understand. The arbitration started on 16th December and the award, and what happened on 8th March?
There was
8th March,
another
there was a
hearing.
sitting. And
So
when,
the 8th March is the
so
award,
two sittings.
two sittings.
And
8th March, the award was passed.
so you were present on 8th March.
I'm not on natural justice. Natural justice.
No,
I'll
no,
be able to
section
show-
18 of the 1996 Act, that I understood. You're on section 18 of the 2006 Act.
I'm on section 18 of the 2006 Act.
18 of the other Act is natural justice.
In natural justice.
Yes.
I am saying that this entire reference in terms of 18.5 will have to be completed within 90 days. After 90 days are over, I'm aware of, I had only referred to Urja and all that, where Arbitration Act will have to be followed. But this is a timeline provided in a specific or a special statute. So special versus general, again, Arbitration Act will become the general, which will be the
Have you paid
procedure.
your 75%?
I paid my 75%. I paid my 75%. So this is the issue that I want to address, Your Lordship. And I don't think affidavits will really
So
change anything.
it's an 18.5 which you want to argue.
Essentially 18.5. The timeline provided in a special statute is strict in nature. One. Second, timeline provided in a, all this is for my learned friends' benefit. Timeline provided in a special statute can be in derogation of or carve out of the Limitation Act. And again, timeline provided in a special statute will have to be given its strictest construction, given the nature of the Act. Here I'm paying.
Commercial Codes Act also has something similar.
I would have relied on that. The analogy is that the interest here, and your lordships know that the interest here is
Same as in 9.2 of the Arbitration Act.
same as in 9.2 of the Arbitration Act. Wherever there is a commercial aspect, here the interest is penal in nature and is 4 times. So even if your lordship returns a finding that 18.5 reference can't be the whole thing, can't be conciliation plus arbitration.
Yes.
Even if it's just conciliation, then that was also not within 90 days. So conciliation, arrow, arbitration. If conciliation goes, basic structure, superstructure. This I have not
Or
really.
superstructure falling.
No, not. This is the long and short of what I intend to address your lordship on. And I really haven't come across a judgment. There are some judgments which are on MSME, what they're going to do, how it's a special statute, but with regard to its timeline, but my learned friend is far more capable. So if you find something, give it to me. This is an interesting question. It's not about who wins.
But why is it a new question? That's my only question.
I don't think this issue has been settled.
It's the statute.
It's a no reference. 90 now the law is clear. The law is clear that this arbitration process will now be in terms of the Arbitration Act.
That's 18.3 onwards.
18.3 onwards.
Yes.
Now 18.5 comes after 18.3. So then what is the reference? This 90 days is conciliation plus arbitration, first issue. Second, if not, then if conciliation goes because it's outside 90 days, with arbitration also go, second.
So if it's conciliation plus arbitration, then it's all right for you.
Also it's gone.
It's gone.
Either way, it's gone. But if on the second situation, if your lordship is not with me, that this 90 days includes conciliation plus arbitration, then I will try and address your lordship on the issue that if the conciliation rolling into arbitration, the conciliation becomes without jurisdiction, then the process of initiation of the arbitration is also gone. That's going to be my second limb. So from both sides, I'll try and attack. Like,
Yes.
Lordship, I was only indicating, Your Lordship, in paragraph 3B of the petition, they have not annexed this main supply order which contains the terms and conditions.
3B.
Yes, Your Lordship, at page 3 of the petition, paragraph 3B.
Yes.
whatever I had, I've annexed.
Lordship, the last line, the petitioner craves leave to rely on the terms and conditions of the supply order at the time of hearing. So if Your Lordship so desires, Your Lordship, I may file
Yes,
an
you can do
affidavit
that.
in opposition, bringing on this on record.
Lord, if he is doing, may I also just request one thing, Lord, would you be
Well, how will the 1 minute? How will the supply order help you, Mr.
Your
Kothari?
Lordship, because it contains the terms and conditions. My learned, in the petition, Your Lordship, in the petition, the petition contains certain allegations that the arbitrator is not considered has gone beyond the terms and conditions. So Your Lordship, I want to bring it on record so that I can differentiate it. Subject to what works
Yes,
from Your
Mr.
Lordship.
Banerjee.
The only request is if your lordship could direct the council to produce the records. Because we have not received the statement of claim, we have not received 2 notices. But there is a finding in the award that
But
this
you
was served.
participated on 8th March.
I participated by just giving one representation, which was also not considered. They did not allow me to file it. So the 8th March final award date, I wanted to give a representation that also they did not allow me to file it. They didn't look at it. Now the statement of claim was also not served upon me. That's my case. Now it could be wrong. I don't want to argue something which will be contrary to the record because they are not really here. If my learned friend can show that this was served on me, then
Anyway,
it'll be
I
good
will
enough.
give you that chance. Or that direction.
Oh, court fee. Well, I told that there's a recent development in other 34 matters where something with regard to 5,000 rupee court fee has been brought up. Ingenious devices to.
But Mr. Banerjee, I should also warn you, and for the benefit of Mr. Kothari, I am going to hear an argument on the point whether if you pay that 5,000 after the 120 days, what is the effect on the 34?
I am paying the 5,000 after 120 days.
No. So therefore, I'm telling you, and Mr. Kothari can also take up that point if he wants to.
Grateful. The only thing is, let that you will decide that issue. I've paid 80 odd lakhs to clear off 75% of my dues. So 5,000, I really would have been an inadvertent. We didn't.
No, it's inadvertent in all cases.
Yes, because we
None of
actually
the
did not
cases,
know.
the people, the council were aware. In fact, I got that notification of 2006, August, brought to the official gazette on 11th October 2006, which says that the earlier Court Fees Act is amended to the extent of 5,000. And I think 1C or 1B says that will come into effect from the date of the notification in the official gazette, which is 11th
Close
October
that.
2006. Yes.
But there's a requirement that if it's not done within 120 days, then it's going to go.
No. That I'm hearing. I will hear.
Someone is actually arguing that.
There's a whole lot of batch of matters where will argue. I've not started hearing that. Will argue. Yes, but if Mr. Kothari doesn't want to take that point, it's gone anyway.
It's fallen from Your Lordship. I'll look into it, Your Lordship. I was also not.
No.
aware.
I just wanted to make you aware of it because otherwise I can't not make you aware. of it.
If he'd come after these arguments are over, then he comes and I might just miss the bus. So I'll come and just hear what's happening. If I see the boat capsizing, I'll probably come and address Your Lordship on this issue also.
The boat may take some time to capsize
Then
or
we'll try
stay
and finish.
afloat.
Stay afloat, whichever way. So at least in course of the day for today gives us the liberty to pay off this 5,000
Of
rupees.
course. Otherwise, you'll be,
Yes,
yes,
we continuing with the default.
yes, yes. This is an application for setting aside of an award passed by the MSME Council on 8th March 2022. Stop. The petitioner was, however, made aware, the award was, however, communicated to the, who is the petitioner before me? Yes, to the petitioner by, under cover of a letter dated 13th April 2023. Stop. Next, apart from the above point, comma, learned counsel appearing for the petitioner also seeks to argue on the strict timeline for making an award under section 18 within brackets 5 of the MSME Act, comma, 2006. Stop. Next, counsel, however, first seeks to top hyphen up the court fees paid for the present application under the 2006, August 2006 notification, capital N, which was gazetted on 11th October 2006. Stop. Next, leave is granted, such leave is granted. Stop. Next, list this matter on. No, actor. The learned counsel appearing for the respondent wishes to bring on record the supply order referred to in the petition. Stop. Next, the respondent shall do so by way of an affidavit in opposition, which is to be filed within
Lordship, as your lordship directs, 2 weeks.
within 2 weeks from date. Reply if any within a week thereafter. Stop. The counsel, then they have to be represented.
They'll just send the records. Manoj.
The counsel is, who will communicate, is directed to, is requested to send the records in the arbitration to the court. Stop. This will be communicated by the advocate on record. This will be communicated to the counsel, capital C, by the advocate on record of the petitioner. Stop. Next, list this matter after 3 weeks. After 3 weeks. Stop.
Grateful to you.
No, actor line likha tha, to when did you pay that 75%? The petitioner has also has already complied with the requirement under section 19 of the MSME Act in terms of payment of 75% of the awarded amount.
By a demand draft dated 27 July 2023
to
the registrar original side.
To, yes, on, as on, what August did you say?
Look, the demand draft is dated 27 July 2023.
Yes, by way of a demand draft dated 27 July 2023 to the registrar original side of this.
Intimation of which was received by the registrar original side by a letter dated 31st July 2023.
Which was received by the registrar original side of this court on 31st July 2023.
Grateful, Your Worship.
Monthly list of commercial division. Item number 38, Messrs. C Nursing Infrastructure. (38) of monthly list, Messrs. Sri Nursing Infrastructure Limited.
কখন থেকে monthly list আছে? না, এটা কি সবগুলো হয়ে গেছে আজকে? 14, হ্যাঁ। Yes. Monthly list কোনটা ডাকলে? 38. দেখি last order. No one appears for either of the parties? Stop. List this matter. On 15 September 2023. Call on the next matter, please. Yes, call on the next matter.
Yes, madam. Item number 40. Hooghly River Bridge Commissioners.
39 টা কি হলো? Yes. This is the second time when the petitioner is not represented. The second consecutive time when the petitioner is not represented. Stop. AP 419 of 2021, along with all connected applications, are dismissed for default. Interim orders of any shall stand vacated. Next.
Item number 41, Shapurji Palunji. 41.
No one appears for either of the parties. Stop. List this matter on 15 September 2023.
Forty-two is an MB Srijan Limited.
But I'd like to appear for the award holder, my lord. Respondent, my
For the
lord.
award data.
Applicant in GA2, which is appearing in your lordship's list today. And my lord, the respondent in the GA1 and as well as the AP, which is section 34, seeking dismissal of the arbitral award. And my lord, unconditional stay, my lord, your lordships had heard it yesterday. My lord, they alleged that there was a fraud in the making of the award.
I'd heard this yesterday.
Yes, my lord, it was Mr. Shakusan was arguing
Yes, my
on
lord,
behalf of
both-
SRM.
Yes, my lord.
SRMD.
I
Both
can't
the
hear
matters
you.
are analogous. So your lordship has kept the other matter on 13th of September, I was told. So
And
let-
you're for the award holder.
I am for the
Yes.
award
So
holder.
let
My lord,
it
we
also
have-
be kept on 13th.
Wait.
We have taken out an application under section 340 of the Code of Criminal Procedure, my lord, alleging that they have made false submissions in their section 36(3) application. My lord, when they were
And Mr. Sen was for the award
for debtor.
debtor.
Yes.
Yes.
Yes, the learned counsel appearing for the parties informed the court that the section 34 application is due to be listed on
13th of September, your lordship.
13 September 2023.
2023.
Stop. List GA2 is for dismissal of the
My lord, this is for my lord, inquiry into the alleged perjury made by the
340.
340, section
Yes.
340. my lord.
And any other GAs?
My lord, no other pending GAs, my lord, the other GAs have been.
Now, what is GA1 then?
My lord, GA, I apologize, my lord, GA1 is section 36,
Six.
subsection 3,
Filed by
seeking
us.
unconditional stay on the arbitral.
Yes.
Your lordship
Yes,
was hearing that.
List this matter along with the application for stay of the award on 13 September 2023.
But pleadings are complete in this application as well.
Very well. Yes.
Deeply obliged, your lordship.
Obliged, my lord.
Item number 43, Rights Limited.
My lord, this is my application, my
My
lord,
lord, I have few
under
to
section
respond.
34 of the Act, my lord.
My lord, on 16th February 2023, my lord, the direction for exchanging affidavits was filed, my lord. Matter was next heard on 21st July 2023 when they didn't appear. Subsequently, my lord, on 3rd August, I have received a copy of their affidavit in opposition. My lord, I'm seeking time to file my affidavit in reply, my lord.
My lord, I seek to file my opposition, my lord.
Why have you taken so much time, Mr.
My
Mukhopadhyay?
lord,
My
File
lord,
the reply.
my lord, I
3rd
received
August,
the
you got
opposition.
it. Today we
Right.
are on 1st
My lord,
September.
since my lord, my clients are based, my lord, in Delhi, my lord.
So
I've communicated it's being drafted in Delhi, my lord. I'm told, my lord, it will take some time. And my lord, their voluminous documents, my lord, 28 volumes, my lord.
yes, the affidavit in opposition of the respondent is taken on record. Stop. Learned counsel appearing with the petitioner seeks time to file the reply on the ground that the affidavit in reply is being drafted in Delhi. Stop. Next, reply to be filed by,
My lord, may I pray for 4 weeks, my lord.
absolutely not. By 15th September 2023. List this matter on 22nd September 2023.
My lord.
read from it.
Actor line is being drafted in Delhi and that the petitioner has received the opposition on 3rd August.
3rd August.
On 3rd August 2023.
My lord, the directions were in February of 2023, my lord, that is why.
I have no doubt, Mr. Mukhopadhyay, that you are hardworking, but Delhi being drafted in Delhi cannot be a ground. Yes.
My lord.
The affidavit in opposition is taken on record. Likhit sir? Yes.
Item number 44,
My lord,
rights limited another.
my lord, similar order can be passed, my lord. It's a different award under a different tender, my lord.
Same order.
Extremely obliged.
Same happens, same order. 45, Mayfair Tie-Up Private Limited. Item number 45 of monthly list.
No one appears for either of the parties. Stop. By the last order dated 21st July 2023, the respondent was to file its affidavit in opposition. By the last order of 21st July 2023, the court, it was recorded that the respondent is still to file its affidavit in opposition. Stop. Next, list this matter on 15th September 2023. Stop. The respondent will file its opposition within the returnable date.
No one happens to other the parties also. Item number 46, Jayaprakash Shah.
I am appearing for the respondent. I am appearing for the respondent, section 34 application.
Have you served the affidavit in opposition?
Yes, my lord. Affidavit opposition is.
No one appears for the petitioner. Stop. The advocate on record of the respondent submits that the affidavit in opposition was served on the petitioner on 21st July.
My lord, my papers have not.
Here are
come.
the order to the. That was a direction on you.
Lord, kindly pass it over, my lord. I can second.
No, what Passover? Submits that the affidavit in opposition has already been served on the petitioner. Stop. Next, list this matter on 15th September 2023.
Forty-seven, Pallavi Sen.
My lord, I am appearing for the respondent. Section 34.
What about affidavits?
My lord, affidavits we have filed.
Not sure.
We have filed.
That's about it.
We have filed, my lord. I'm
Same
extremely
order.
sorry, my lord, my papers have not come.
Same order.
Item number 48, Lil to Mehna.
My lord, I am appearing for the respondent.
Say something more, Mr. Chaudhary. Not only appearing for the respondent.
My lord, affidavit has been filed by us.
Yes, no one appears for the petitioner. Stop. The advocate on record of the respondent submits that the opposition has already been filed. Stop. List this matter on 15th September 2023. Stop. Protecta order likhe dao to. The respondent's advocate on record shall communicate this order on the petitioner. Protecta.
Item number 50, State Bank of India. Item number 50, State Bank of India.
No one appears for either of the parties. List this matter on 22nd September 2023.
'51, Ali Hassan Mondol.
I am appearing for the respondent. My lord, kindly, I am praying for only not today. My lord, I have to ascertain whether I have.
Why not today? Absolutely not. You're there. Why did you not get your papers, Mr. Chaudhary?
This is my fault, my lord.
Every matter you're saying the same thing? You were, there was a direction on you. Auditor dakho to.
Yes, miss, I know.
There was a direction on you to file the opposition. Have you done it or not?
My lord, kindly give me second call, my lord. I'm just.
What second call? Absolutely no second call. Yes, the advocate on record of the respondent is not sure whether the direction in the order dated 15 June 2023 has been complied with. Stop. List this matter on 8th September 2023. Stop.
Item 52, Alauddin Sheikh.
My lord, I am appearing for the respondent. I am also, my lord, there was also a direction, my lord, filing it.
Have you done it or not?
Lord, in this matter also, I have to check my records.
Same order.
Item number 53, the New India Assurance.
No one appears for the party, for either of the parties. Stop. It is therefore not clear whether the affidavit in opposition has been filed. Whether the affidavits in opposition and reply have been filed as directed by the order dated 5th July 2023. Stop. List this matter on 22nd September 2023.
Item number 54, Rahim Molla. Item number 54.
No one appears for either of the parties. Stop. Hence, there is no indication whether affidavits are complete as directed by the order dated 4th July 2023. Stop. List this matter on 22nd September 2023.
'55, Badshah Ahmed.
My lord, this is an appeal, my lord. We are opposing in this matter. Our affidavit has been filed.
Can't understand.
My lord, this appeal, my lord, under section 37, challenging an order under section 17. My lord, this appeal, my lord, we have filed our opposition. My lord, this matter was ready for hearing. Mr. Priyankar.
So affidavits are complete.
Yes, my lord. This is ready for hearing.
Yes, the advocate on record of the respondent informs the court that affidavits are complete in the matter. Stop. List this matter on 22nd September 2023. The advocate on record is requested to communicate this order on the petitioner.
Primark Tilumala project.
Your Lordship, my application. Your Lordship, affidavit in opposition has been filed by the respondent. Your Lordship, I need 1 more week's time to file my reply.
When did you get it, Mr.
Your Lordship, the opposition was served on 18th of July.
18 July?
Yes,
Then
Your
what were you doing all this while, Mr. Mitra?
Your Lordship, the dealing advocate was hospitalized. It's my mistake. I was.
What dealing advocate?
Your Lordship, my colleague was handling this matter. So suddenly he was hospitalized. We need, it's in 3 days we will file the reply.
Yes, the advocate on record of the petitioner seeks a week's time to file the affidavit in reply. Stop. List this matter on 15 September 2023. Reply to be filed in the meantime, and this order is to be communicated to the respondents.
Grateful, Your Lordship.
57, the HON'BLE Mills Company.
My lord, this is my appeal under section 37, challenging an order of the my lord learned arbitrator, my lord, by which the arbitrator has stayed the arbitral reference. Application filed by the respondent in the reference, saying that stay the proceedings till such time a challenge to an award arising out of an eviction proceeding is decided by this court. I had the occasion to move this application once before your lordship. My lord, the sum and substance is, my lord, this was disputes arose out of a leave and license agreement in respect of 2 shop rooms, my lord, situated in, my lord, E-Mall in Central Avenue. My lord, it was commercial, used as a commercial space. My lord, there were 3 agreements in respect of each unit. One was a leave and license agreement, and 2 separate, my lord, facility service agreement and maintenance agreement. Now, the disputes with regard to leave and license agreement, when section 11 was filed, we were referred to the arbitrator. My lord, arbitrator passed an award of holding, my lord, that there will be an eviction of the respondent. And so far as, my lord, the claims with regard to facility and service agreement and maintenance service agreement, the proceedings were pending before the arbitrator. Now, because the respondent has challenged, my lord, the award of eviction before this honorable court, and there is a stay, my lord, the respondent files an application in other 2 references saying that till such time this court decides the section 34, please don't proceed to hear with the other 2 references. And the learned arbitrator has stayed the proceedings, my lord. My ground of challenge, my lord, would be that first, my lord, the Arbitration and Conciliation Act, there is no provision in the act.
So it's from an order under 17.
My lord, the application has to be treated as one under 17 because there is no other provision. So, my lord, I filed a 37 appeal.
No, what do you mean by has to be treated as a 17?
Because, my lord, there was no nomenclature, my lord, in the application as such. It was an application filed, I presume. My lord, the last limb, in fact, lordship had indicated this to me on the last occasion, my lord, that's or such further order. So he possibly falls under that limb. And my lord, he files this application, my lord, praying for stay of the reference. Arbitrator has allowed the application.
Yes.
My lord, my grounds of appeal would be primarily 2-fold, my lord. One is, my lord, the application itself is not maintainable because, my lord.
So application, as in the application filed by the respondent.
By the respondent before the arbitrator.
Claimant.
Respondent is, no, he is the respondent in the reference.
You're the claimant.
I am the claimant.
And the application, what was the prayer in the application?
To stay all further proceedings in the arbitral reference till disposal of the section 34 proceeding, which is pending before this court. That section 34 arises out of an eviction award.
Very well. So how can the application be made after filing of the award, after the award was passed?
No, my lord, there were three references.
Yes.
One reference out of the leave and license agreement, which culminated into the eviction award.
Yes.
The other two references were pending and it was going on before the same arbitrator because issues were common, parties were same. So it was, my lord, we only suggested to the, my lord, section 11 court that the same arbitrator be appointed. Once, my lord, he delivers award in the eviction proceeding, he stays, my lord, on that application. He decides that I'm going to stay these references because the challenge to the eviction award is pending before this court. I say, my lord, neither the application filed by the respondent is maintainable under the, my lord, provisions of the act, nor does the arbitrator has jurisdiction to stay his own proceedings. The act does not, my lord, envisage a situation or giving power to the arbitrator to stay its own proceedings. My lord, termination is there, my lord, in the act, termination of mandate. Situations, various situations are contemplated. But to stay, my lord, that is only possibly the power of, my lord, High Court. My lord, either, my lord, a section 9 or something, my lord, court can, my lord, yes, of course, stay the proceeding. But arbitrator possibly did not have this jurisdiction. On these two grounds, my lord, I want to, my lord, satisfy, but I don't find, my lord, the other side here.
So if the other side is not here, what happens to your arguments?
Well, I can continue.
You want a clapping or what?
No, my
Then?
lord, I can continue.
Yes.
My lord, then I
Just,
start. I start with the, my lord, impugned order, my lord.
No, just tell me the law on the subject.
My lord, then kindly takes the, my lord, Arbitration Act, my lord. The Arbitration Act, I only show two provisions, my lord.
17 and 37.
17 and yes. My lord, first takes, my lord, section 17, my lord.
Yes.
In fact, my lord had referred to when I was placing this provision, my lord, on the last date,
Yes.
17 Roman 2E, lordship had, my lord, indicated that this can be invoked. My lord, I want to make a distinction. If your lordship sees the language, my lord, one starts with the language. A party may, during the arbitral proceeding, apply to the arbitral tribunal, and then, my lord, the various subclauses are there. So, my lord, the condition precedent is that during the arbitral proceeding, for interim measure, this kind of this application can be made. It is not, my lord, this provision does not give, my lord, or it's not an enabling provision for a party to apply to have the proceeding itself stayed. A party may, during the arbitral proceeding, apply to the arbitral tribunal. Then, my lord, kindly takes Roman 2 for an interim measure of protection in respect of the following matters. So, my lord, 17 can be invoked only for an interim measure of protection in respect of the subject matter.
Yes.
And my lord, Roman 2E is such other interim measure of protection as may appear to the arbitral tribunal to be just and convenient. My lord, the prayer made in the application for stay of the reference does not fit in this definition, either of the, my lord, various, my lord, subclauses of Roman.
So the arbitral tribunal could not have held that it's just and convenient to stay the arbitral proceedings.
Because
Could not
it
have.
could not
Why
have.
do you say that?
My lord, because, my lord, it is not an interim measure of protection. The interim measure of protection with regard to the subject matter, my lord, this was a dispute arising out of a facility service agreement. I say, my lord, as the claimant, I am entitled to a particular amount of money in terms of the facility service agreement. The respondent denies that. Now, the, my lord, respondent's case is that since the eviction order, which has been passed by the arbitrator in the other reference, is under challenge, the issue whether the respondent is a licensee or a tenant is now pending before the Honorable High Court. And there is a stay, my lord, of the passed by the High Court, affirmed by the Supreme Court now. On a condition, my lord, of payment, they would continue to occupy the property. On this ground alone, they say till such time my right as a tenant or a licensee is finally adjudicated by the court, I should not be compelled to proceed with this reference. Although, my lord, these references were being, my lord, it was at a stage of examination of witnesses. My witness was being examined. And there was a prior application made in these references when the my lord, respondent wanted stay of the proceedings. The arbitrator held that I am going to continue and I will continue till the stage of passing the final award. This was the arbitrator's own finding in a previous order in the same reference. Then he, my lord, again undoes that and, my lord, passes this order staying the reference. Now, if your lordship also sees, my lord, section 32, my lord, of the Arbitration Act. My lord, this talks of termination of proceedings.
Yes.
The arbitral proceeding shall be terminated by the final arbitral award or by an order of the arbitral tribunal under subsection 2. Arbitral tribunal shall issue an order for the termination of the arbitral tribunal where claimant withdraws his claim or parties agree on termination or tribunal finds continuation of the proceeding has for any other reason become unnecessary or impossible. My lord, even if I look at 2C, my lord, this is also, this says that the arbitrator can terminate or pass an order terminating the mandate, saying that it is unnecessary or impossible. But this also does not give the, my lord, jurisdiction to the arbitrator to stay his own proceeding. And, my lord, I visualize this, my lord, from another angle, my lord. If your lordship also, my lord, takes note of, my lord, section 29A. My lord, the mandate of the act is that the tribunal has to, my lord, after completion of pleadings, my lord, within 6 months from entering upon reference, it is a period of 12 months within which, my lord, the tribunal has to publish award. That 12-month period can be extended by consent by the parties for another 6 months. So, my lord, the act also envisages a speedier disposal of the, my lord, proceeding. So, if I take that, my lord, consent period of 6 months, my lord, it is 1 year, 6 months or 1.5 years. My lord, by this method, my lord, if the 34, my lord, today, my lord, is pending for a while, and my lord, even thereafter, even if your lordship takes up the 34, my lord, there would be 37. There can be further challenge to the 37 order, and this may take some time. I might cross this, my lord, deadline, my lord, and then the issue will come whether I need to apply for again extension of mandate, because the mandate, my lord, will expire. He only stays the proceeding.
Yes.
But the period, my lord, the clock starts clicking, my lord, from the date he enters upon the reference. So, my lord, even, my lord, looking at, my lord, the provision in 29A, it is, my lord, the arbitrator's duty to, my lord, conclude the hearing within the, my lord, statutory period. And of course, my lord, if the parties consent, within the extended period. Now, if your lordship sees the, my lord, impugned order, the reasoning given by the learned arbitrator, my lord.
No, Mr. Dotto, you will do that on the next one. All right.
Very good.
I will start on the next.
I will only show, my lord, after that order, one judgment of Bombay High Court. My lord,
saying what?
My lord, that arbitrator has no power to stay the proceedings.
Under 17(2)(e).
Yes.
17(2)(e), no power. Yes, learned counsel appearing for the petitioner, for the appellant, who seeks to argue on the point of the absence of any power of the arbitrator to stay the arbitral proceedings in respect of 2 other references. Is that correct?
Yes, my lord, actually it is 4. My lord is dealing each individual appeal. There are 4 appeals.
In respect of other, in respect of other pending references, will continue with his submissions on, give me a date, please, Mr. Dotto.
My lord, next Wednesday, that's my lord.
The respondent has never appeared or what?
No, my lord, they appeared. Mr. Shubhashish Sengupta was appearing, my lord. My lord, I can come back on 6th or 7th if lordship permits.
No, it will
7th
be
is a holiday, I'm sorry, my lord.
it will be a Friday.
My lord, then my lord, 15th.
এটা কি শুধু শুক্রবার অন্য দিন তো হতে পারে? Very well. Come back on 12th.
12th, grateful, my lord.
On 12th September 2023, stop. Counsel is requested to communicate this order on the respondent.
Surely, my lord.
Item number 50. Item number 58, Hooghly Mills.
My lord, same order can be passed.
Same order.
Item number 59.
My lord, same order.
Same.
Item number 60.
This is the 4th one, my lord, same order.
Same order.
Grateful, my lord.
Yes, call on the next section.
Item number 61.
Yes. 61 টা ডাকলো তো। Yes.
Daily list, commercial division, examination of judgment debtors, item number 70.
For the judgment data.
My lord,
I can't hear you, Mike.
I am for the award holder. This is my execution application. I have two seniors leading me in this matter, Mr. Ratnanko Banerjee and Mr. Shaunak Mitra. I'm on instructions to seek an accommodation for today.
What do you mean? The judgment debtor
Judgment
is in
data is
court.
present, my lord.
I will impose costs on you for making these kinds of submissions.
No,
You're
my lord,
seeking an adjournment if the judgment debtor is in court. Do the work,
my lord,
please.
I was on instructions, but if your lordship insists, I shall begin.
How can you even ask for an adjournment? And that too on the ground of seniors. Next time you do that, I will impose costs.
Lord, my apologies, I was just on
Yes,
instructions.
put the,
My lord is outside for this.
yes, call him, please. Where is he?
My lord is out.
Just go outside. You go outside and call him. Don't go on pointing at the door.
Sorry.
Yes.
Come here. Yes. What is your name?
It is my vomit.
Lord, may I file the supplementary affidavit, my lord, your lordship had given
What is
the
that?
supplementary affidavit, my lord.
Yes. The supplementary affidavit of the judgment debtor number one
There's only one. Only one judgment.
of the judgment debtor is taken on, is filed in court today and taken on record.
My lord, kindly a copy be served on us, kindly direct.
Yes, yes, already served? Yes.
My lord, we haven't been served. That's my instruction.
Show me evidence, please, of the copy being served on them. Show me evidence, please.
Your age?
67.
67. Your residential address?
D101.
11th August 2023.
They'll give a copy. my lord.
Yes,
Very well, your lordship.
at the first instance, comma, learned counsel appearing for the petitioner, for the award holder seeks an adjournment on the ground of his seniors not being present in court. Stop. At the second instance, comma, counsel submits that the award holder has not received a copy of the supplementary affidavit of the award debtor. Stop. The letter, the document placed before the court shows that the award debtor, that the award holder received the copy of the supplementary affidavit on 11th August 2023. Stop. The handwritten endorsement forms part of the document. Stop. Next. It is unbelievable that when a judgment debtor is present in person to be examined in court, comma, adjournment is being sought for on the ground of senior counsel not being present. Stop. The second desperate attempt to seek adjournment is on the basis of the supplementary affidavit not being received.
My
Stop.
lady, I'm ready to examine.
Next.
Kindly accommodates. I was on instructions. I'm ready to examine.
Very well. I will in any event impose costs. Continue, please. There is no point in the court working so hard if counsel and their advocates on record are so lax
My ladyship. my
Every
apologies.
matter I will now start imposing
My
costs.
ladyship, my apologies. I will begin with
Continue, continue.
What is your name?
Your address.
B for Bombay, 101
B101
Greenwood Housing Complex,
Greenwood Housing Complex,
Koikhali Main Road,
Koikhali Main Road,
Kolkata 700052.
70053. Occupation, what is the occupation?
Service.
Service. Yes, sir.
What is your name?
Jyotirmay Bhaumik.
How are you associated with the award debtor?
I'm one of the board members.
Who are the promoters of the, sorry, who are the promoters of the award debtor?
Who are the promoters of the award debtor?
India Power Corporation Limited,
Indian Power Corporation Limited. And
then Power Trust and BSPL.
Power Trust and BSPL.
Can you indicate if the,
BSPL, yes.
can you indicate if the award debtor has filed the
You
statutory
want your
returns?
evidence to go down or not?
My lord, I'm just asking for some.
Do you understand what the
Yes,
court
yes.
is telling you? The evidence has to go down, so pace it out.
Yes, yes, your lordship, I'll do that. Have you filed the statutory returns?
There is some issue.
There is some issue.
Statutory return means what? Yes, all statutory returns are filled up.
All returns are.
To the best of my knowledge, all statutory returns are filled up. Only the balance sheet we have not filed up. There is some
Only
issue.
the balance sheet we have not filed.
Would you be in a position to,
Accounts rather.
would you
Accounts.
be in a position to disclose the returns as well as the statements, financial statements that have been filed?
No, that's all right.
Can you indicate? Can you indicate what are the assets that are available in respect of the award debtor?
I've already filed it. I have assigned it.
You stated that there are certain issues regarding the statutory returns that you filed. Can you indicate what are those issues?
No, I said that we have not filed the accounts latest.
We have not filed the account, latest account.
Can you indicate till when the accounts have been filed?
I think 1920.
1920, since when the accounts have not been filed? 1920, since 1920, I'm sorry, since 1920. 1920 or 2020?
FY 20.
Would you be able to?
1919, that's it.
2019, 2020.
2020, yes.
Would you be in a position to disclose the last return that has been filed by you?
No, I think I'm sorry. I don't remember it, but it is a loss. We are making loss. Actually.
Yes, ask him to go a little slow.
It is a
please.
loss.
Please go.
It is lost.
It is lost.
It is we are loss making company.
As we are a loss making company. It is lost, that's sure.
We are a loss making company.
No.
Have the Can you indicate if your company maintains the ledger accounts?
I think so. Yes.
What is so funny? Ask him to answer the questions properly, please.
Please
Sorry.
answer the question.
Yes, sir.
Probably don't laugh on me. Just answer the question, that's all.
Would you be in a position to disclose the ledgers?
I am mostly in the technical side. Actually, I'm in the technical man basically.
I am a technical man basically.
I am a Jadavpur engineer.
I'm an engineer from Jadavpur, Passing out from Jaipur University.
I was in NTPC, then I joined
Huh?
here. I was in NTPC.
I was working with NTPC, now I have joined. this
Here, so here actually it is, I'm mostly looking after the technical, all the issues and commercial issues
I mostly look into
The technical. or
and commercial issues.
commercial issues of the company.
Can you indicate as to how many bank accounts does the award debtor have?
Yeah, 14 accounts.
14 accounts.
14.
Would you be in a position to produce the bank statements pertaining to those 14 accounts, as you mentioned?
Actually, they are all mortgage and we have to take the permission. They are all mortgage with the REC and PFC Limited.
REC and BFC.
PFC.
PFC Limited. All mortgage. Right.
They are all
Yeah.
mortgage with REC and PFC Limited.
So we have to take the permission from them.
We have to take permission from them.
Would you be in a position to take the necessary permission and disclose the same before this honorable court?
Yeah, if the court,
Yes, say yes. No,
yes.
Yes.
Does your company maintain, does the auditing of the financial statements?
Excuse me?
Sorry, I'll
Auditing,
repeat the question.
Done to your,
What is the question?
auditing is done to the financial statements every year.
I'll repeat my question. So my question to you is, does the award debtor audits its accounts?
Up
Say
to,
yes.
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 Would you be in a position to disclose the audited accounts of pertaining to your company?
Audited accounts of your company.
Yes, if required,
Yes,
if required.
if required.
So you stated that you are a loss-making company. So my question to you is, how does your company continue with its operations in the present day?
How the company is running.
Yeah. Our EBITDA is positive, but our
Our EBITDA, EBITDA.
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 is positive,
Positive.
but there is some issues with the loan structure, which the interest,
Loan structure. With
so the interest is not clarity. We are it is not, we are unable to pay the
able to pay the
actually the restructuring program has been going on. So,
restructuring process has been going on.
so the clarity of the interest is not there.
The clarity of the interest is out there.
So unless and until that is resolved,
Unless and until that is resolved,
the original interest burden, there is some loss. With the original interest burden, there is some loss.
with the original interest burden, there is loss. Burden.
Can you indicate as to how many employees are working with you at the moment?
Yeah, around 250.
Don't say yeah, say yes.
Around
Around
Yes,
250.
You stated that you are a loss-making company. So how does your company give salaries to such employees?
I told you that EBITDA is positive.
As I told you, EBITDA is positive.
Could you elaborate, please?
EBITDA is earning before interest and and
EBITDA is earning before interest
tax.
and tax.
So earning constitutes of the revenue and the O&M expenses.
Earning consists of revenue and
Revenue minus the O&M expenses.
less O&M expenses.
And
Revenue less
Less.
O&M expenses
and less raw material cost.
and less raw material cost.
So in the O&M expense, already the salary part is included.
So in the O&M expenses, salary part is included.
Are the salaries of the workmen who are working in your company paid up to date?
Yes.
Yes.
Is there any evidence to support that the salaries have been paid up to date?
I don't have now, but we can produce.
I don't have it right now, but I can produce it later on.
Would you be in a position to disclose the same before the next day's hearing?
The next day when we come before, we will be in a position to produce that.
Yes. Yes.
How many offices does your company have?
We have registered office in Salt Lake, Kolkata, and our
Registered office in Salt, our registered office is at Salt Lake, Kolkata and
our main plant.
what main plant?
In the main plant in Haldia, we have the
We have the main plant at Haldia. Plant.
Are there any other branches besides the ones you mentioned?
Apart from these two, are there any branches?
No.
No.
You are Mr. Das, Raheja or Banerjee?
I'm sure the manager, Your Lordship.
Banerjee, very well. Yes, tell me when I will put the matter and you will put the questions, not your seniors.
Very
When
well,
do
Your
I put the
Lordship.
matter?
My apologies, I was on instructions, but I totally understand.
I asked you a question, answer that question.
Yes, Your Lordship. Lordship kindly keeps it next week.
Next week,
On
you will
Friday.
continue, not your seniors.
Very well, Your Lordship.
Yes, learned counsel appearing for the award holder who has conducted the examination in the cross-examination to an extent today will continue on 8 তারিখে কটা আছে দেখো তো? On 8th September 2023 as prayed for. Stop. Next.
My lord, I just want to apologize for
Yes, that's all right. Call on the next
a
matter.
junior
please.
member. I'm learning. I'm very
That's
thankful to
fine.
Your
Yes,
Lordship.
call on the next matter, please.
I'm grateful.
71. Nawala housing.
71, in this matter, I am appearing on behalf of award holder. The warrant has been issued against the award data number 1 and 3. I think today the sheriff to file report regarding the execution of the warrant. Let's see.
When were the warrants issued?
Warrant has been issued on 7th March 2022. Thereafter, time to time, warrant has been extended by that. Large extension has been done on 12th May 2023.
এটা কি ট্রান্সলেশনটা আছে এখানে নাকি?
PC 83. PC 83.
Warrant was issued when?
On 7th March 2022. Last extension was on 12th May 2023.
Last extension?
12th May 2023. It is extended by
Very well.
14 weeks.
The handwritten letter dated 1st May 2023 from the senior SP, Patna, to the OC, Gardni Bagh, Gardni Bagh Police Station is placed on record, is placed before the court. Stop. The advocate on record of the award holder submits that the warrant of arrest was issued first on
7th March 2022.
7th March 2022 and extended on 12th May 2023. Stop.
Last extension on 12th May 2023.
And was last extended on 12th May 2023. Stop. The SP. It does not appear from the records that the SP has filed, has complied with the direction of the coordinate bench of 12th May 2023, directing the SP to file a report as to why the warrants of arrest have not been executed till date. Stop. Next. The SP, Patna is hence directed to file a report by 19th September 2023, 18th September 2023. Stop. List this matter on 22nd September 2023.
Can I extend the written date of the warrant, madam?
Yes, the warrant is extended till 29th September 2023.
Great.
Yes, the award holder shall put in the requisites in the meantime.
Okay.
Next.
Item number 72, Kotak Mahindra Bank.
Lordship, the sheriff has to file a report in this matter.
SP to kono report file kore naki to? Yes, it does not appear from the documents placed before the court that the SP has complied with the order passed by a coordinate bench on 12th May 2023 in the matter of filing a report. Stop. Next, the SP is hence directed to file a report by Aki date 18th September 2023. Lists this matter on 22nd September 2023. Concerned to be to pull. The concerned SP.
Item number 73, Poonawalla FinCorp.
I am appearing on behalf of award holder, my lord. I am appearing on behalf of award holder. In this matter, the award dated number 2 has filed their affidavit of asset. The date for examination has been fixed, but last 2 occasions they have taken time. That there is some difficulty regarding the train booking, something like that. So I think
My lord, on 21st July 2023, he was present in court. On that day, it was no, not to pass any adverse order was there.
Not to pass any adverse order.
21st July, he was very much present in court because of some Michil and all. He just walked through from Howrah station and he came to court before my lord. And
Where is he coming from?
From Mumbai, my lord.
From Bombay.
Yes.
So give me a date when he will be here.
My lord may fix any date. But
Give me a date.
My lord may fix any date, but it should be bit long, my lord.
Yes, the advocate on record of the award debtor number 2 submits that the award debtor number 2 was present in court on 21st July 2023 21st July 2023 was, what happened on 21st July?
Some Mitchell was there.
So was he present in court?
Yes, my lord. I came before my lord and I submitted before my lord that.
But could not be examined because of a procession, allegedly because of a political procession on that date. Stop. List this matter on 22nd September 2023. Stop. The award debtor number 3 must
Two.
be present.
Two, my lord.
The award debtor number 2 must be present in court for examination.
Only one thing I'm thinking, respondent number 3, the wife of the 2. She has not filed affidavit of asset. Kindly
lord.
my lord, direct them. She has.
Yes, the award debtor number 3, comma, who is the wife of the award debtor number 2, comma, shall file her affidavit of assets by
My lord, I have to take instruction because I am appearing only for judgment data number 2. I have to take instruction, my lord.
29th September 2023.
Okay.
74, Kotak Mahindra Bank versus Rubo Wellness.
Lordship, I am appearing for the award holder in this matter. Lordship, by an order dated 17 February 2023, Lordship, they had filed an affidavit of assets. There were no supporting documents. By 12th May 2023, there was direction to give the documents and also their income tax return. Thereafter, which was given, thereafter on 7th of July 2023, it was Lordship ordered to furnish the balance sheet for the last 5 years and to come for examination. They have not furnished with the documents, Lordship.
So they have not filed the balance sheets
Yes, Lordship.
of
they
the
have-
last 5 years, comma, bank accounts,
Yes, Lordship.
and also what else?
Lordship, that was what was required. That has not been filed.
No one appears for the award debtors. And it also does not appear that the award debtors have complied with the direction passed by this court. Directions passed by this court on 7 July 2023. Stop. List this matter on 8 September 2023. Stop. For due compliance of the order, as stated above, stop. The advocate on record, the bid of the award holder shall communicate this order on the award date in the course of the day.
July. 8 July. 75, Poonawalla Housing.
75, I'm appearing on behalf of award holder. I have instruction from my client, my lord, they have approached for settlement. I'm praying adjourned for a 6 week at least, my lord.
Who is they?
The award daters.
Say that.
Yes, my lord. Award data have approached.
Yes, the advocate on record of the award holder seeks adjournment on the ground that parties are exploring a settlement. Stop. List this matter after 6 weeks as prayed for.
Good.
76, Poonawalla Housing versus Rajendra Lal.
In this matter, my lord, I have also received instruction from client, my lord. They have, the award debtor have approached for settlement and adjourned for 6 weeks.
Same order.
Good.
Seven, Kotak Mahindra Bank.
Lordship, I am appearing for the award holder. The sheriff has to file a report in this matter.
Seventy-five, 76 or PK contract. Yeah, the order.
এটাকে
এটা সেও
রিপোর্ট কি ফাইল করেছে? Or extended in the report of the SI of police, Bishnupur, dated 17th August 2023 states that the warrant of arrest could not be executed since the warrantees are absconding. Stop. The report states that the police have taken further action to execute the warrants. Stop. Next, the report, next, in view of the report, comma, the warrants of arrest are extended and the police are directed to take due steps under the warrants. Stop. List this matter on. Tell me, Ms. Das, when?
Lordship, third week of September, Lordship. Third, fourth week of September.
On 29 September 2023.
Gainwell Commercials Private.
বুঝেছো? মনে করে দে।
Lord, I appear for the decree holder. For the
78.
award. But on the last occasion, your lordship had directed the judgment letter to appear for examination. Where it was indicated that he resides in Australia. I believe, my lord, he's present for examination.
Yes, he's currently employed in Australia, but he's here. But he's ready to depose.
WFA or WFH? From home or from anywhere?
No, any, from the place concerned. but-
Yes.
Let him.
Yes.
Humbly affirm,
I solemnly affirm,
whatever I shall depose, I shall speak the truth, nothing but the truth.
whatever I depose, I speak only truth, nothing but the truth.
Your name?
Kiran Reddy,
Kiran. The father's name?
Balakoti Reddy,
Balakot.
Balakoti Reddy.
Koti. Balakoti. Yes. Your father, your age?
38.
Okay. Oh, you've already deposed on you.
Yeah, last time, I guess,
Oh.
counted back.
Please go slow. Whatever you will be saying, that will be recorded.
Sure.
Mr. Reddy, where do you reside in Australia?
Perth.
What takes you to?
Mr. Ghosh, pace yourself out, please.
Yes.
The evidence has to go down.
Yes. Mr. Reddy, what do you do in Perth?
I work for a mining company and we got a mining contract there in Western Australia.
And we have got a mining contract in Western Australia.
I am heading the Australian business.
I am heading the Australian business.
Mr. Reddy, what is the name of the mining company where you are employed?
BGR Mining,
BJR.
BGR, that's the Indian company. They got a subsidiary in Australia.
That is the Indian company, they have got a subsidiary in Australia.
Are you a shareholder of BGR Mining?
No,
Are you anyhow associated through your any other associate concerns or companies or undertakings with BGR Mining?
no,
Associates? Associate? And-
What are you doing, Mr. Ghosh?
Lord,
You
because.
want the evidence to go down or
Yes,
not?
my lord,
The witness may not know, but you should.
Yes. Are you anyhow connected to BGR Mining through any of your concerns, associates or undertakings?
Your answer is?
no. When I work for the company,
In what capacity do you work for the company?
I am head marketing and collaborations.
Head marketing and collaboration.
What was your designation in the judgment debtor company, Kridya Infra Limited?
I am the managing director and shareholder of the company.
You're still the manager.
Yes.
I am the manager.
Mr. Reddy, how are you associated with the company which goes by the name of Balki Infra and Projects Private Limited?
That was also, I am the MD of the company.
Would your answer be the same for the? I am.
That company, that was a 10-year-old, 12 years old company, which is not in function for last 10 years, right?
That is a 10, 12 years old company, which is right now not functioning. Is it?
Mr. Reddy, can you produce your income tax returns for last 7 years?
Yes,
Mr. Reddy, can you also produce the returns along with the balance sheet, the profit and loss account, and the sales register, the purchase register, and your trial balance for the company, for the judgment debtor company for last 5 years?
Kridya Infra you're talking about.
Yes.
Yes. I mean, whatever is available, I can provide. I don't know what is available, but I will talk to my auditors.
Whatever is available, I will provide. I don't know what will be available. What will be available.
Mr. Reddy, would I be correct if I said that the judgment debtor was previously known as Shaili Paradigm Infratech Private Limited?
Yeah, the same company, yes.
Don't say yes. Say yes.
Kindly have a look at this document. Give me copies. These.
Yes.
Do you find description of properties on the right hand side?
Yes.
Are these properties still mortgaged?
I need to check. These are, I think, mortgaged with SBI before, and some properties have been auctioned. So I have to check which one is still there with SBI.
Which one is still there?
There with SBI.
Who auctioned the properties as deposed by you?
Sorry, I did not understand.
Who understands? Who
Auction the
auction the property?
The bank, SBI.
Mr. Reddy, who are the other directors and promoters of the judgment debtor company?
Other directors' names are Srujit Reddy and Govardhan Reddy. Srujit.
Reddy and Govardhan Reddy.
And promoter, there is one Arun Jupalli.
Jupalli. What's the spelling?
Arun Jupalli, Jupally.
Promoter.
Mr. Reddy, are these directors related to you?
One director is my cousin brother. Yes, thank you.
Who are the shareholders of the judgment debtor?
I am the major shareholder.
The judgment debtor company is still in business?
No.
Mr. Reddy, can you indicate why you had to take up a job in Australia?
Because my company has been bankrupted.
Is there any insolvency proceeding pending against your company?
I mean, I don't understand that legal terminology, but there are some cases going on in DRT and with other banks, which I owe money in the company.
With other banks.
Say bankruptcy. It will be bankrupt. You just say bankruptcy.
Has there been any proceeding for bankruptcy as against your company, as in the judgment debtor company?
No. I think bankers are in their procedure. I don't know at what stage they're.
Bank hai?
SBI and Corporation Bank, Bank has gone to DRT. If that means the proceeding, then
If that will be proceeding, then that is the problem.
What is the name of the company in which you're employed, which is the subsidiary of the Indian company in Australia?
it is also called BGR Australia.
BGR Australia.
Where is the principal place of business in India of BGR infra or mining, whatever you said?
Hyderabad.
Mr. Reddy, would I be correct if I said that BGR is an undertaking with which you are associated through various other entities by means of cross shareholdings?
No,
Mr. Ghosh, let the court know when you want, at which interesting juncture you want this to end.
This has to come to an end now. Because, my lord, I'll produce documents and because he's not able to travel. This is the first time he has come. So, my lord.
No, I thought you, didn't you
have-
say that he's here? He's
He
based
is-
here.
Yes, in the last order, my lord, it's recorded. that
Yes.
he would be.
And he'll be available.
Lord, I only think if he can complete it today, that was my request on the last occasion.
Otherwise,
Not possible in the next 3 minutes.
After 2 o'clock, if it commences to your,
No. Where does your client stay?
he lives in Perth.
Perth.
Yes.
Didn't you say that he works over there, but lives here?
No, my lord, he currently is in Perth. So he has to travel, my lord, it takes 48 hours. I've asked him, it takes around 48 hours to come and, my lord, go back.
Very well. Now he's in Calcutta.
No, my lord, he has his tickets booked, but he can, of course, reschedule.
Tickets
them.
booked when?
He has his tickets booked. I don't know, my lord. He's just
tonight.
Tonight, my lord, at 9 o'clock, I think.
Today, tonight? Your client should have expected that it will be concluded in one sitting. Not possible.
Mr. Reddy, what is your current salary?
in India,
Wherever you're drawing a salary, I believe. So what is your current salary?
annual package would be maybe around 34-35 lakhs.
We'll continue, my lord. Next. I've asked for the income tax returns as well.
Yes, in any case, he has to produce those.
I'll produce it, my lord, much before the next date, so that.
Yes. Mr. Ghosh, how much time will you take in any case?
Well, if I'm given the documents, I'll cross-examine him once more and that will be the end of it.
No,
Because probably half an hour maximum.
Very well. So when will you come with the documents? Ask your client, please.
And can you give the documents?
I mean, how much time today?
No. When can you give the document?
How many days?
I have to check, I mean, maximum, but I have to travel back here, right? I cannot come until for another 1 or 2 months.
But when can you- when?
Mr. Ghosh, what about the examination through?
I can do it. If he provides the documents, I can do it on the virtual mode as well.
That would be my lord.
Yes. So how much time will he
Lord,
produce
within
the,
a fortnight, my lord, we can.
within
give
a
the-
fortnight?
Yes.
And what were those documents? I just remember the last 7 years and last
Lord,
5 years.
The income tax returns for last 5 years, the income tax returns, the balance sheet, the sales register, the purchase orders.
And he's the managing director of the judgment debtor.
Yes.
Yes.
The
And-
deponent, who is the managing director of the award debtor, will furnish the documents which form part of the cross-examination today within a period of a fortnight from date. Stop. List this matter on 29 September 2023. Stop. The deponent, comma, who presently lives in Perth, 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 comma, Western Australia, Perth, comma, Australia, comma, will continue with the cross-examination on the virtual mode as prayed for. Stop. What are you waiting for? Yes, call the next matter. Yes. Mr. Mukherjee, this is not the time to mention.
The monthly list, item number 40, my lord. Told my lord, we were not present. My lord.
Mr. Mukherjee, no. You will have to wait till Monday.
My lord, I'll come back at.
No, no mentioning out of turn.
The lordship will sign the order, my lord.
No. Yes, call on the list, please.
Non-commercial matter. Item number 1 for judgment, Sharad Chatterjee and Co.
This court does not see any reason either on the facts presented or in the law or in law on the subject to stay the impugned award dated 14/1/2023 on the strength of the division bench order of 29/7/2015. The reasons for this view are indicated in the foregoing paragraphs. The petitioner's prayer for unconditional stay of the award is hence rejected. AP 265 of 2023 is disposed of by giving liberty to the petitioner to furnish security to the extent of rupees 18,21,74,768.50, half of which shall be by way of cash deposit and the remaining by way of a bank guarantee. The petitioner shall deposit the cash component plus bank guarantee to the registrar original side within 8 weeks from the date of this judgment. The award shall be stayed from the day following the petitioner depositing the full security in terms of the direction. The award holder shall be at liberty to execute the award after 8 weeks if the petitioner chooses not to comply with this direction.
Good.
Yes. Yes, call on the next matter, please. To be mentioned, right?
Item number 2 to be mentioned, Kamlesh Kumar Singh.
I appear for the respondent, my lord.
Yes, the application was disposed of. The application filed by the petition was disposed of by a judgment dictated in court yesterday, i.e. 31st August 2023. Stop. The matter, however, is appearing in the list today only for the purpose of the court informing the council that one of the reasons for dismissing the application has been modified. The decision, however, remains unchanged. Stop.
I'm good.
Let this order be made part of the judgment dated 31/8/2023. Actor line after that. One of the reasons that on closer consideration of the 7th schedule, one of the reasons for dismissing the petition has been has been modified. Stop. Next.
2 PM matters, examination of judgment debtors. Item number 31.
I appear, my lord, for the decree holder.
I appear for the
On the
judgment
last
debtor.
occasion, an adjournment was taken by the judgment debtor on the ground that they're going to give a proposal for settlement. No proposal have come forward. In fact, on 2019, my lord, there are two orders, 2nd of August 2019 and 30th August 2019. Adjournment was taken by the judgment debtor on the ground that they want to pay off the decretal dues. No decretal dues, though part has been paid for the
one,
last
please,
4 years.
take it out. Yes, Mr. Bhattacharya.
Yes, my lord. There are two orders of 2019, 2nd of August 2019 and 30th August 2019, where it is specifically recorded that the judgment debtor was willing to pay off the decretal dues. That is after, my lord, he was substantially examined as a judgment debtor. Thereafter, even thereafter, not a single penny has been paid. As on date, the decretal dues are rupees 33 lakhs. On the last occasion, on 4th of August 2023, an adjournment was taken on the ground that they want to give a proposal for settlement. No proposal received.
Yes,
Nothing.
Mr. Gaurav.
My lord, today is fixed for examination of the judgment debtor. My lord, what my learned friend said, no proposal given. My lord, I'll have to take instruction, my lord. Today he was supposed to be present in court for the examination, my lord. He is having fever. He has handed over.
Where does he stay?
He stays in Calcutta only. Your lordship will keep it any other day. He will come to before your lordship.
On another occasion, my lord, adjournment was taken on the ground
Had
that he had
conjunctivitis.
conjunctivitis.
Last
Today
occasion he
has
was present.
fever.
We had, my lord, last occasion he was present in court.
Let him
But
at
today
least
he is
come in
unwell.
as to how he's going to pay in terms of what is recorded in the August 2019 order.
Very well. I will make that direction on you. All right. Yes, the judgment debtor who was supposed to be examined in court today is not present. Stop. Learned counsel appearing for the judgment debtor submits that the judgment debtor is not well. Stop. Next, a list this matter on 8th September 2023 for under the heading examination of judgment debtors. Stop. Next, the judgment debtor shall also file a proposed settlement in terms of the directions passed by a learned single judge of this court, comma, as his lordship then was, comma, on 2nd and 30th August 2019. Stop. The proposal, an advance copy of the proposal shall be made over to the award holder by 8th September 2023.
Grateful, my lord. Decree holder. Decree holder.
Yes.
Instead of award holder, my lord, decree holder.
Decree holder.
Obliged.
Grateful, my lord.
32 Kotak Mahindra Bank.
This is my execution application, my lord. This is my execution application. By order dated 15th May 2023, my lord, the superintendent of police was directed to file a report. A warrant of arrest was issued. The judgment was not presented by the police. So a report was supposed
Judgment
to.
debtor was not present then by the police means what?
I apologize, my lord. The warrant was issued, my lord. On that day, the police was supposed to bring the judgment debtor. The judgment debtor was not presented that day by the police. So a report was supposed to be filed by the police, superintendent of the police. By the order, it was directed to the police, my lord.
My lord, I beg to appear on behalf of the judgment debtor. My lord, I beg to appear on behalf
I
of
can't hear you, microphone.
My lord, I'm audible, my lord.
Yes.
My lord, I beg to appear on behalf of the judgment debtor, my lord. Judgment debtors are present in court, my lord. I received the brief on Monday, my lord. My lord, for that reason, I could not prepare myself. My lord, kindly grant me
Doesn't matter.
2
Let
weeks
the
time.
cross-examination start, then yes,
They need
put them
My
on
lord,
the
they need to
box.
file the affidavit of arrest. They have not filed yet.
Not filed.
No.
Very well. And they were supposed to file it when?
My lord,
Yes, let me see the judgment debtors. Call them here, please. Very well. They were supposed to file it when?
But I apologize, that order is not with me, I think. I
Very
apologize.
well. Both the learned, both the parties represented through learned counsel are not ready to proceed with the matter. Stop this matter on 22nd September 2023.
Deep
Next.
level, madam.
The judgment date or numbers,
Only in item, there are one judgment data in each matter, my lord.
the judgment debtors are present in court.
My lord.
Yes, the warrants of arrest shall be kept in abeyance
Hello.
till counsel are ready to make their submissions. Next.
33. Madam, again, the similar order may be passed, my lord, in the similar.
Yes,
judgment
same,
date, madam.
same.
I apologize.
34 Poonawalla Housing Finance.
I'm appearing on behalf of award holder, madam. I'm praying 4 weeks time. In this or some instructions required from client, my lord. I'm praying for 4 weeks time, madam. In this matter, what happened, they have taken steps, my lord, and asset has been sold by.
Yes, the Algorithm record of the award holder seeks adjournment, seeks an adjournment, lists this matter after 4 weeks as straightforward.
Item number 3, Mampi Haldar, Builder.
In this matter, I am for the petitioner, my lord.
For the alleged contemners, number 1 to 3. My lord, we have, my lord, may I file a report that we have initiated the process of her passport renewal, but
Not renewal, but
fresh, my lord, I'm sorry, I stand corrected. But the police verification, my lord, is pending. Lord, without the police verification, it's
Mr. Bhattacharya, the other day you were in a terrible hurry to cross the road.
my lord, when
Yes, because one of my colleagues' cars was going and you apparently stopped the car and you crossed the road.
I don't recall, my lord.
That was what was reported to me. And in fact, I assured them too that I will speak to you. Apparently their car was coming out and you were crossing, and in a great kind of exasperation, without even looking at the car, you just did this.
I'm sorry, if your lordship indicates who they are, I will personally go and apologize. But maybe there was something, my lord, there.
And if suppose they are busy, then what will you do? You will bang the door and get in and say sorry, and then bang the door again and get out.
Possibly I did not realize, my lord, maybe there was something. Again,
That's all right. I had told them that I would speak to you because I didn't
apologize,
want,
my
I didn't want
my lord can convey my
any kind of escalation. So I thought I told them that I will speak to Ms. Bhattacharya.
I convey
Well,
my apologies.
Yes. Yes, Mr. Bhattacharya.
Yes, my lord, we have initiated her process, but her police verification is still pending. Till the time the police verification comes, because the earlier police verification said that she is not a citizen of India. So that verification is awaited. Till that comes, my lord, we can't process her passport.
Lord,
Yes.
I do not have, admittedly, my lord, I do not have, my lord, birth certificate, my lord. My birth was at residence, my lord. They asked for, they made so cause and asked for clarification, my lord. I submitted clarification. Lordship asked them to consider my clarification. Lordship, for one moment, my lord, see the order, my lord.
Mr. Bhattacharya, what are you saying? That the police verification is awaited?
Yes, my lord, yes, my lord will kindly see the report which I have handed over. My lord, paragraph 4, the file is pending at the end of Bidhannagar East Police Station and police verification report is awaited. So till the time the police verification report comes, we can't process unless they say, yes, she should be issued a passport. We can't do anything. They cannot
You're Mr. Jaiswal?
Jaiswal, Lordship.
Yes, Mr. Jaiswal, then you may have to make the police a party over here.
They are the respondent number 4.
Grant me the liberty, my lord, I will make him party, my lord. Bring to
No.
party. Lordship.
No, they are parties, my lord. I think they are
No.
respondent number 4, officer in charge. Officer in charge, Bidhannagar East Police Station is a
No,
party.
but they're not the contempt, no, before the court,
Not the contempt.
not the alleged
Not
contempt.
the
no.
alleged contempt.
Yes, learned counsel appearing for the
Respondents 1, 2, 3, my lord.
regional passport officer / alleged contemnor number 3 submits that the order passed by the court, that the order dated 8th May 2023 cannot be complied with until the police verification comes in. Until the police verification is received by the authorities, by the alleged contemnor. Stop. Next, learned counsel appearing for the petitioner will take the required steps to make the concerned police authorities a party to the contempt application. Stop. List this matter on when?
Your lordship's contempt.
List this matter on
My lord,
22nd.
I can indicate where the files are pending.
1 minute, 22nd September 2023. Yes.
It's indicated in the report. It's before the Bidhan Nagar East Police Station, SP Office, District Bidhan Nagar. So,
May I
accordingly.
make him the party, my lord, because he's the concerned officer, my lord.
Grateful, my lord.
Yes, Mr. Bhattacharya, just tell me once more, please.
Yes, my lord, the concerned police station, your lordship will find at the report.
লিখে নিন যেটা বলছিলাম।
Bidhan Nagar East Police Station, SP Office, District Bidhan Nagar. Grateful, my lord.
Item 4, Sumon Shaw and another.
4 and 5, my lord, I have instruction to appear on behalf of the respondent.
4 and 5.
My lord, I am appearing for the petitioner. Affidavit of service.
Yes. Yes. Yes, yes.
This is my restoration application. Matter rejected on 5th April, Honorable Chief Justice Sabyasachi Bhattacharya. Restoration filed on 10th August 2023.
Is it outside the?
Along with delay condolence.
Within limitation?
No. Beyond the limitation, my lord, in my copy, even not how it has not been quantified, not how much is the delay. It's blank. Lord, I have quantified, it's more about not 100 days.
Delays of 100 days. So should have been filed on?
Lord, it's 5th of April 2023. So 4th of May 2023 should have been filed.
Yes, there is considerable delay in filing of the present application for
Delay condolence is filed, my lord.
for recalling an order dated 5th April 2023, whereby the arbitration petition was dismissed for default. Stop. GA1 of 2023, which is for condoning the delay, has a blank space in prayer I of the application. Stop. The application, the application is not drafted, is not properly drafted is not properly drafted and needs to be filed afresh. Stop. The petitioner is given leave to withdraw both the applications and file afresh.
I'm so grateful.
Stop. The file afresh, subject to the applications being filed within a week from date.
So
Item number 6, Graphite India Limited versus New India Assurance.
My lord, this is our 29A application, my lord. The mandate has expired on 31st August, my lord, but this is the first extension application and we have filed it before the expiry of the mandate, my lord. This arises out of the
How
dispute
do,
arises.
how do I know 31st August?
My lord, I'll indicate you. My lord, page 61, my lord. Where the 6 months extension with the consent of the parties have been recorded. At page 62, my lord.
Yes, what do you have to say?
No, no objection. Your
What is the stage of the arbitration?
My lord, arguments on behalf of the respondents is.
So you have finished.
We have finished, my lord.
Then why have you asked for 6 months?
My
3
lord,
months? 3 months at best.
my lord, the arbitrator has also requested because he has to publish awards and there were 5 witnesses, my lord, so that also have to be taken into
No, arguments
consideration.
are going on now.
My
Then-
lord, arguments have to be gone into, but there are voluminous papers, my lord.
No,
actually.
no, every matter has voluminous papers. Yes,
My lord, My lord,
no,
there
no,
are,
no.
my lord, the respondent will require 4 or 5 more sittings to complete their arguments, my lord. Thereafter, there will be rejoined.
You mind about your own business. All right.
My lord.
Don't speak for the respondents.
That was
Yes,
indicated.
this is an application for extension of the arbitrator's mandate under section 29A within brackets 4 of the 1996 Act. Stop. The mandate ended on 31st August 2023, as is recorded in a minutes of sitting held on
21st February, my lord.
21st February 2023. Stop. The present application was filed on 29th August 2023. Stop. Next. Since the present application was filed during subsistence of the mandate and the respondent does not object to further extension, and the fact that the parties are already at the stage of arguments, AP 622 of 2023 is accordingly allowed and disposed of by extending the mandate for 4 months from 31st August 2023. From 31st August 2023. Stop.
My lord.
Next.
Item number 7, Nitin Singh Thakur.
Time for the petitioner, my lord. No, the affidavit of service, my lord, that's served.
Yes.
My lord, the award dated, my lord, 19th April 2000.
Can't hear you.
My lord, the award dated, my lord, 19th April, my lord, that has been challenged, my lord, before your lordship, my lord.
Where's your respondent?
Served, my lord, I've served my copy, my
When?
lord, served twice. This, my lord, the latest service.
When is the last time you served them?
Initially, my lord, there was an order of service, my lord, I served them that from the track report, it could not be ascertained that they have received, my lord. Subsequently, I've served again.
Yes. Where is your award?
My lord. Starts at, my lord, page 10 of my application, my lord.
Yes.
The award dated is, my lord, 19th April 23, my lord. My lord, it arises out of an agreement of 15th July 2018, my lord. A loan agreement, my lord, that was, my lord, granted, my lord, by the respondent to the petitioner, my lord. There was some default in respect of that, my lord. The arbitration proceeding was initiated. My lord, the sole contention, my lord, of my client at this stage would be, my lord, that nowhere during
Affidavits are over in this matter.
my lord.
Affidavits are done.
No, nothing.
What do you mean? Nothing. Is there a
First time,
direction for
my lord,
that?
appearing for first time.
Yes, the affidavit of service shows that the respondents have already been served Stop. None of the respondents are, however, represented. Stop. Next. List this matter. When do you want to come back? Inform them. Let them be here.
My lord, anytime as well. Lordship would sit.
You better get ready in the matter. All right. Are you going to argue the matter?
My lord.
Then get ready properly. List this matter on 25th September 2023. The advocate on record of the petitioner will communicate this order on the respondents.
My lord.
Item number 8, Mrs. Care Pumps and Company. Appearing on the respondent.
No one appears for the petitioner. List this matter.
This is the last chance, Lordship, for making pre-deposit.
This is the second consecutive day when the petitioner remains unrepresented. Stop. AP 540/2023 is accordingly dismissed for default. Interim orders, if any, shall stand vacated.
Chamber applicant foreign disposal, application 9 to 13. Matter 9 to 13.
What were you trying to mention, Mr. Mukherjee?
Lord, it's mentioning item number, monthly list item number 14. My lord.
You were not here. Give the item number to my court officer. I will put your name.
Obliged, my lord.
It was dismissed for default. File an application.
My lord, that's humbly beseeching, my lord.
File an application.
My lord, this is, my lord, that matter regarding this is the matter regarding two wills, my lord. There's a prior will and a subsequent will. Subsequent will is the will which is probate of which I'm seeking, my lord.
Yes.
And the property in Mussoorie.
Mr. Medora was
Mr.
appearing.
Medora was there in the
Yes,
contempt
sir.
application.
Led by
Yes.
Mr. Medora.
My lord, here there are 4 or 5 applications which are there, my lord. GA1 was my first application where your lordship had passed certain interim orders restraining the my lord, the caveator, Mr. Medora's client, from dealing with the Mussoorie property. My lord, GA1 was my first interim application where, my lord, your lordship was pleased to pass an order restraining Mr. Medora's client from dealing with the Mussoorie property, as also there's a Salt Lake property in Calcutta, subject matter of the bill. Then, my lord, there is GA3, which is my second application which I had filed seeking further orders, where, my lord, I had found, my lord, that by sale of portions of the Mussoorie property, they had, my lord, made around 6.5 crores or so. So I wanted, my lord, relief in the nature that, my lord, they secure that 6.5 crores which Mr. Medora's client has obtained by selling part of the Mussoorie property.
Yes.
In that, my lord, your lordship had passed an order that post 1st July 2021 was the order where, my lord, Mr. Medora was restrained.
Yes.
Post that order, whatever money they have received, those money should be kept with the Registrar High Court. I am pressing GA3 now, my lord, for further orders, including the order, my lord, that the entire money which Mr. Medora's client has received prior to 1st July 2021 also, in relation to sale of the property, that entire money be deposited with this court. That's what I'm praying right now. That's GA3, my lord. Then there is, my lord, GA6, which is relevant right now. GA6 is again an application by Mr. Medora's client asking for vacating the 1st July order, which was passed, my lord, in GA1. They have taken two primary grounds. One, they are saying, my lord, that the prior will, in terms of which Mr. Medora's client is claiming a right over the Mussoorie property, that will was not required to be probated because the property is situated outside Calcutta. So there is no requirement of a probate, and therefore under section 213, they had a right to deal with the property.
Yes.
So on that basis, the interim order which has been passed, that should not have been passed. That is the first case they've made out.
Yes.
Second, they say there is suppression.
Yes.
And what is the suppression? According to them, the suppression is that I have not pointed out that the first will was not required to be probated. That is the case made out. It's a roundabout case. Under Order 39, Rule 4, the case which is required to be made out for vacating an interim order, that case has not been made out. It is just a case that legally under Section 213 of the Indian Succession Act, a probate of the will is not necessary. Therefore, they have a right to deal with the property. Therefore, no interim order should be passed. But there is the argument absolutely is fallacious, because here the issue is with regard to the second will. My lord, it's a settled law that it is the subsequent will which has to be decided. If the subsequent will is proved to be correct, has been executed properly, and probate is granted, then the first will automatically goes. So the person who's claiming under the first will have no right whatsoever if the second will is proved. So the entire argument, because the first will is not required to be probated, so therefore he has a right to deal with the property, therefore the interim order should be vacated, that I don't think holds good at all. Secondly, they can't make that argument at all, because, my lord, this property, the subject properties concerning the first will also, in terms of which Mr. Merora's client is claiming a right, that will, my lord, the property is not isolated to only Mussoorie. There's a property in Calcutta also. So therefore, by virtue of Section 213, any will, subject matter of which is a immovable property which is in Calcutta, that has to be probated.
Yes.
It can't be said, so far as the Mussoorie property, no requirement of a probate. But so far as the Calcutta property, probate is required. So therefore, I can deal with the Mussoorie property. So that argument also possibly will not hold good. So, my lord, let me place, my lord, the sections, because my learned friend had already completed their arguments on Section 213. They had placed two judgments also.
Mr. Mukherjee, Mr. Merora, this is a matter where some
There's a contempt application which is also
that
pending.
payment made
Yes,
this, that.
Yes,
That's a
this is the contempt application.
That is coming up next week.
Yes.
Contempt application. My lord, I am right now, my lord.
Thank God for small mercies.
For us also, my lord.
Yes.
Well, lord, I am right now asking for two reliefs. One is the vacating application that should be dismissed. And secondly, in GA3, where I've asked for further orders, those further orders should be passed also in lieu of the conduct of Mr. Merora's client. I will show, my lord, I'm also going to rely on, my lord, because it's court records, my lord, in the contempt application, my learned friend has filed affidavits. Those affidavits will also show that how they are dealing with the property. It's a circuitous transaction. It's a round tripping of funds. What Mr. Merora's client has done, my lord, is parts of the property has been sold to nominees of Mr. Merora's client only.
And how have you been able to identify that?
My lord, one of the it's been sold to various people. One of the people, the two persons to whom it has been sold, one is an LLP. Of that LLP, the majority shareholder is Mr. Merora's client's wife. And the other person to whom the property has been sold is one of the other partners in that same LLP and in his individual status. So obviously there is a link. So, and there are also other transactions to one Dhanpal Rawat. That Dhanpal Rawat admittedly is a caretaker in that property who has purchased the property for 90 lakhs. So whether the funds have come, how the funds have come, it's obviously just for the purpose of creating encumbrances, creating further, like a list pendants, further liabilities. These transactions had been done, but the property is still in his name only through his nominee or through his through someone else whom he has full control over. So that is why, my lord, that's one case. So therefore, the monies which he has received, admittedly he has received because these are all registered deeds, which shows, my lord, the total amount which he ought to have received from the sale of all the properties is 6.18 crores, which includes the part of the money, 88 lakhs, which he has received after 1st July. That is the subject matter of contempt, whether he has received that 88 lakhs or not. That is the subject matter of the contempt post 1st July 2021. But prior to 1st July 2021, he has admittedly received approximately 5.2 crores by sale of various parts of the property. So since on the face of it, at least 3 of the transactions, my lord, your lordship will see, are circuitous or roundabout or round tripping, where, my lord, the property is being sold to one of his nominees only. So obviously the other transactions would also have to be in that spotlight. And in any event, he does not have a right over the property till such time this probate is not granted. The probate of my will is not granted. If it is rejected, only then. If probate of my will is granted, then he does not have any right anyway. So any argument that he makes, the money is the estate's money, and that has to be preserved or protected. And that is my prayer in my second application. My lord will kindly take, my lord, section 213, which my learned friend is relying upon. That is his case. Only section 213. Whether that at all, my lord, has any legs to stand. Section 213 of the Indian Succession Act, my lord. My lord, I have a copy, my lord. Photo copy আছে 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 Section 213. They've relied on section 213 read with section 56. I will place both the sections, my lord. I have no, my lord, issue with the proposition of law that if the property is outside, then there is no question of probate of the will. But here, my lord, the properties are both outside and inside. Therefore, probate is necessary. And in any event, my lord, this is a subsequent will. So he cannot rely on the first will till such time the subsequent will probate is rejected. So, my lord, if your lordship takes 213 first, my lord. Right as executor or legatee when established. No right as executor or legatee can be established in any court of justice unless a court of competent jurisdiction in India has granted probate of the will under which right is claimed or has granted letters of administration with will or with a copy of an authenticated copy of the will annexed. So this provides, my lord, any will that has to be probated. Unless it is probated, my lord, the executor or the legatee, my lord, cannot act on it, on the will. But there is an exception, my lord. This section shall not apply in case of wills made by Mohammedans or Indian Christians, or shall only apply in case of wills made by Hindu, Buddhist, Sikh, Jains, where such wills are of classes specified in clause A and B of section 57. My lord, B, Roman 2. In case of wills made by a Parsi dying or after commencements of Indian Succession Act 1962, where such wills are made within the local limits of ordinary original civil jurisdiction of high courts at Calcutta, Madras, and Bombay, and where such wills are made outside those limits insofar as they relate to immovable property situated within those limits. Well, interpreting section 213, subsection 2, Roman 2, well, Supreme Court has held that if the will is made outside Calcutta, Madras, Bombay, then, my lord, it is not required to be probated. Or if the property, the immovable property, is situated outside these three jurisdictions, my lord, then the will is not required to be probated. They are relying on this provision, read with section 56. But if I may place section 56 also. No, 57, my lord.
Yes.
Testamentary succession, section 57. Application of certain provisions of part to a class of wills made by Hindus, etc. The provisions of this part, which are set out in Schedule 3, shall be subject to restrictions and modifications specified therein, apply to all wills and codicils made by any Hindu, Buddhist, Sikh, or Jaina on or after the first day of September 1870 within the territories which at the said date was subject to the Lieutenant Governor of Bengal or within the local limits of the ordinary original civil jurisdiction of the courts of judicature at Madras and Bombay. So, my lord, interpreting this, my lord, they are saying, my lord, that the will of my learned friend, which was executed outside, is not required to be probated because it concerns a property in Mussoorie, which is also outside West Bengal, outside Calcutta. Well, now, this is Calcutta in the olden days, so it's a larger part, my lord. Calcutta, Madras, and Bombay. But my lord, if your lordship takes that previous will, I will show it, my lord. The prior will also, as also the will which I'm asking.
You're relying on the subsequent will.
I'm relying on the subsequent will. They are relying on the prior will. Both the wills, my lord, the subject matter, the immovable properties which are subject matter of the wills, my lord, it includes outside as also inside. So if there is a property,
Calcutta and Mussoorie.
Calcutta and Mussoorie, they are saying, so far as the Mussoorie property is concerned, I don't require a probate. Calcutta, they are not claiming any right because they are saying I'm not getting any probate. They've kept silent about the Calcutta property. But as soon as there is a property in Calcutta, my lord, section 213, this exception will not apply. It cannot be so, my lord, logically, that you only ask for probate of the will so far as Calcutta is concerned and not so far as the Mussoorie is concerned. That is not what the section says. Section says if the subject matter of the will, the immovable properties, are outside, then probate is not required. As soon as there's a property inside Calcutta jurisdiction or Bombay or Madras, then probate will be required. So their argument that section 213 applies, therefore, probate was not required, therefore they had a right to sell the property, and therefore no order of injunction should be passed, that does not lie good.
Yes.
That's my first point. So judgment, they've cited a judgment of Supreme Court on this point. I'm absolutely agreeable to that proposition. There's no fault, nothing wrong at all, my lord. If the property was outside, if the will was executed outside, then these provisions would have applied. Rather, the exception to these provisions would have applied. But then again, my lord, my next argument, these provisions don't apply at all. Because, my lord, they are not of no concern at this stage, because right now we are concerned with a subsequent will, probate of which, my lord, I'm asking from this honorable court. And for preservation of the estate, my lord, these orders can be passed. First will is there, not there is immaterial today. What is necessary is probate of the second will, granted or not granted. Once it is not granted, once it is rejected, then the right accrues. Then my case would be, once the second will is rejected, or the probate is rejected, if at all, in that case, I would argue that still they require a probate.
Yes.
As of today, their probate granted or not granted of their will is immaterial. Well, just like in the Villa Lodha case, there's a, your lordship knows, there's a will of 1982, which was in favor of the so-called the Billas, and my lord, the probate, the will of 2004, which is in favor of the Lodhas. So Supreme Court, my lord, in that in the SB Sinha in 2008, my lord, he held that first, what has to be decided is the probate of the second will. If the probate of the second will is granted, then the rest of the proceedings is rendered otiose. Only if the second will is not granted, the probate of the second will is not granted, then the question comes whether the first will is required to be probated at all or not.
Yes.
So, my lord, will kindly take, my lord, GA3. My lord, show, my lord, the provisions of the will, the part of the will.
Mr.
which
Mukherjee, you another 5 minutes, because from 3 o'clock I have my appellate side. I want to call on one or two other matters also.
Well, then should I'll take some time to show all these provisions also. My lord, show both the wills, and my lord, then also some judgments on
No, provisions you have already shown. 213 and 56.
Provision terms of the will. Terms of the will, subject matter of the will includes property in Calcutta, which they also.
So you're saying that the provisions will not be applicable, or rather 213, 56, both will not be applicable because you're relying on a probated second will.
Yes, asking for a probate of a second will.
Asking for a probate on the second will.
That's my first argument.
That's your answer. So whether part of the property or part of the property in the will is in Calcutta, the other part is in Mussoorie, is that relevant or not?
It's not relevant, but since they have taken the point, my answer is there for that also. And my lord, your lordship will see from their application, that's GS6, they have not made out a case for vacating of the interim order. My lord, Order 39, Rule 4, which is for vacating an interim order, there has to be material suppression of facts, which was known to me, or some kind of undue hardship which they are going through. They have not made out those cases in their application. So they can't ask for vacating the interim order. Rather, I am asking for further orders on that basis, my lord.
No, have they filed an application?
They filed, my lord. GS6 is their application for vacating. It is in that application, their case, my lord, is that no interim order could have been passed because of section 213. That is why, my lord, I was pressing on section 213 first on that point.
And did they rely on 56 as well?
57 and section 213, these two sections.
Okay.
My lord, I would, my lord, since it's part of the court records, although my lord in the contempt, but the affidavit which they've relied on, I'll be relying on that affidavit to show my lord that the round tripping which is happening, only for that purpose.
Round tripping, Kolkata, Missouri and back.
Well, round tripping of the funds. Well, this is a new term, my lord, we are using a lot in NCLT, my lord, now. The round tripping of funds which is being done. So, my lord, here, as I said, my lord, there's Neeraj Khanna, Mr. Merora's client, my lord. He is claiming right as executor of the prior, executor as also legatee of the prior will, on the basis of which he's selling parts of the Mussoorie property. He has sold it to several people, including one, which is a caretaker of the property for 90 odd lakhs. Secondly, he has sold it to a LLP, of which the major shareholder is Mr. Merora's client's wife. And thirdly, to another person, an individual, who's a partner in
Why
this
can't
LLP.
you say Mr. Neeraj Khanna's wife? Yes.
Mr. Neeraj Khanna's wife.
Still obsessed with me.
Yes.
So those, well, only I'll be relying. What I've done is, my lord, I've made a compilation only of these documents which are part of court record only, since they are in a different proceeding. But since it's court record for that purpose, I don't want to make any affidavit. Just as a compilation, I'll be doing. My lord, the interim order is expiring, my lord, also.
On
Expired yesterday.
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 I'll deal with all these allegations.
No, I'm not finished. I'm not
Oh,
finished.
Round tripping. He hasn't gone into the hitchhiker aspect. Maybe you'll send me to another galaxy then.
I'm sure you can
Yes.
go. Leave the will to me and the court.
Yes,
4 and K5, which are Millard, for discharge of KVA Millard lodged by you.
Lodged by?
So-
Discharge of KVA Millard filed Millard by step brother.
There's another person.
Yes.
So Millard, I have a KVA table interest Millard. He says I don't have. Since I'm a step brother.
Learned counsel appearing for the petitioner, who seeks to argue that none of the provisions relied upon by the respondent, namely sections 213 and 57 of the Indian Succession Act, 1925, will apply to the facts of the present case, since the petitioner is seeking to probate the second and the subsequent will of, who is this?
Anirudh Chamaria.
Of Anirudh Chamaria. Stop. Council also submits that the properties are based in Calcutta and Mussoorie as an additional point in his arguments. Stop. As an additional point. Stop. Next, GA1 is of the petitioner seeking further orders.
But GA3 is my application for seeking further orders. GA3. GA1 was my first application where.
Yes, GA3 হবে.
GA3.
And what is, which one is yours?
GA6.
GA6 is by the respondent who seeks vacating of the order
1st July 2020.
dated 1st July 2021.
2021.
2021. Stop. Next, Lysis matter on, give me a date, please, Mr.
I'm ready any day, my lord. Only 11th, my lord, is the only date I was requesting.
Lysis matter on 12th September 2023.
The interim order may be extended.
Yes, the interim order next, the interim order which expired yesterday, i.e. 31st August 2023, is extended till 5th December 2023.
Grateful, my lord.
Now item number 14, Farm Developments Limited.
The lordship, in this matter, Mr.
Section 11.
Accommodation was appearing on behalf of the respondents and making submissions. Lordship, we are in the process of engaging another counsel. If roughly 10 days time can be.
Why do
given.
you want to engage somebody else?
Because he is not available, we can understand. So if we can, by the,
No, he can appear online.
can appear, but he is not well, he is not keeping well. That is what I'm, so we are in the process of engaging another senior counsel. Though there is a junior counsel, but we are in the process of engaging another senior.
Yes.
Cannot
10
oppose,
days
I
time.
know, because what is.
What has happened to Mr. Sen?
It's
Even the
back
back
problem,
pain,
he,
back-
Sorry?
back problem, he
back
cannot
problem.
get up, he's.
Very sad. No, he appeared before me
He
online.
appeared in some matters, he is appearing. That is a fact. That is-
In fact, in this matter is a checkered history, long history, one round
Yes.
of litigation over till Supreme Court. I also need to give you.
As a matter of fact, there was a review application in which there is also an application pending of the state for extension of the matter.
Yes, the advocate on record of the respondent seeks time on the ground of the counsel representing the respondent being seriously unwell. Stop. List this matter. Tell me, Mr. Shah.
Next week.
Not next week, also 10 days time. Your Lordship. So that we can get the next week.
List this matter on 13th September 2023 as per.
কিচ্ছু বলেন।
Allow করে দিয়েছে।
15, Ranjana Khajana.
May it please your lordship, my lord, I appear on behalf of the petitioner. This is my section 11 application, my lord. I am led by Mr. Arif Ali. Been unwell, he's not come to court this week, my lord. I'm humbly praying if lordship is pleased
You
to
better
keep-
tell me what the dispute is about.
My lord, this is a development agreement of a particular place in
Because
South
both
City.
Mr. Torokdar and Mr. Mukhopadhyay, you are always ready in your matters. Tell me.
My
what the
lord,
dispute
here,
is
may I
about.
just indicate before my learned friend starts, my lord, I had taken on the last occasion the point of, my lord, insufficiently stamped document, my lord. And my lord had directed them to go to the, my lord,
To impound, have the
to
document
impound.
impounded.
It was
Done
sent
that.
to the
No,
collector,
my
my
lord,
lord.
it's in the process of being done. We were given a form by the Kolkata collectorate. We are yet to take steps on that regard. That is the limit of my instruction, my lord. I'm sorry.
So tell me, Mr. Torokdar, how much time do you want?
My lord, I am instructed to request your lordship to keep it anytime next week. But
Are you there in the matter?
yes, my lord, I am,
You
but
are.
I've been.
Yes, the order dated 27 July 2023 records that the arbitration agreement is an insufficiently stamped document, and the petitioner was given leave to have the document impounded for assessment of the stamp duty payable. Stop. Next, learned counsel appearing for the petitioner seeks time on this count. Stop. List this matter after
But any day next week, my lord.
next week. Your this assessment exercise will be done.
I cannot tell your lordship
Then-
candidly, but
You don't know they take minimum 3 weeks,
they take a couple.
even though it's 27 July. I don't know what you've done. Very well. List this matter on 11 September 2023 as paid for.
Grateful, my lord.
Deeply obliged, my lord.
Sixteen, Srishti versus Anandi Kumar Maji.
But I am for the
I
petitioner.
am for the respondent.
Sole respondent has died on
He has
25th
died on
July
27th.
2023.
Are you going to both submit together? What happened?
I am for the petitioner, ma'am.
Yes.
The respondent has died on, sole respondent has died on 25th July 2020. So I need to substitute the legal layers. my lord.
Yes, that's Mr. Chattopadhyay's client. Learned counsel appearing for the respondent submits that the respondent passed away on
25th July.
25th July 2023.
25th July 2023. Stop. Next, what is this application for?
Section 11.
Section 11.
Yes. Next, hence the respondents legal representatives will have to be brought on record. Stop. Next, counsel is given, a learned counsel appearing for the petition is given leave as prayed for in this respect. Stop. Next, list this matter after.
After 2 weeks. my lord.
List this matter after 3 weeks.
Grateful, man. Great.
My lord, these my applications. This one affidavit to reply, my lord.
So may I file my opposition?
My lord, the only objection is the res judicata, my lord.
Sorry,
Only objection by their side is the res judicata, my lord.
res judicata.
Yes.
Res
That, my lord,
judicata of what?
because the earlier one award was passed.
What is the objection, Mr.
Only
Kothari?
res judicata, my lord.
Your Lordship, this is the second attempt for arbitration. Your Lordship, there has been a previous arbitration concluded, award given. On this, they had won the award. Your Lordship, I am the award debtor. No section 34 preferred. They file a fresh section 11 application. No execution preferred as well. They file a fresh section 11 with respect to the same disputes and arising out of the same partnership agreement and between the same parties. Your Lordship,
But you're saying that the award was given in their favor.
yes, Your Lordship, they won. I offered them the amount, the awarded amount. They refused to take it. Now they go and file a section 11. So let them argue, Your Lordship.
That section 11 could be decided by the arbitral tribunal. The res judicata question of res judicata could be decided by the arbitral tribunal. My lord, my first arbitration award was on the clarification of the account. The section 21 notice issued on the clarification of the account, my lord, and the second reference was made on the dissolution of the firm, my lord. Both references are different. The earlier,
Clarification of account means what?
there is some frivolous transaction was happened.
Understand my difference.
There was some frivolous transaction happened, my lord.
You have to tell me first
Yes.
who you are, who Mr. Kothari's client is.
I'm the partners, my lord. I'm the partners, and they're also the partners of the firm, my lord. My lord, kindly take, my lord, the earlier reference.
They're all Buiddos. Who are they? Family members?
Yes, my lord, family members.
Yes.
Kindly come page 32 of volume 1.
Yes.
These are the deed of partnership. November 2008. Then we would kindly come page 39. Then we would kindly come page 36. There is an arbitration clause in the agreement. Then note this arbitration agreement has been amended by mutual parties, agreed by the mutual parties at page 39, my lord. Amended arbitration
Just
clause.
show me the award, the reference. You have to
Yes,
deal
I'm
with the
coming to
res
the
judicata point.
Yes,
then.
my lord, I'm coming to the reference. Then, my lord, kindly come at 108. The arbitral award was passed on the first reference. Is at 108 of this volume. My lord, the third paragraph.
This is the award, 108.
No, this is the reference, my lord, I'm coming.
Yes.
That my client serve you a notice dated so and so, whereby request you to clarify certain transactions. My lord, what happened? The money come from sale of the assets, that money taken away by different way in the name of commissions, so and so, that's the matter. My client, being a partner of the said firm, seeks your clarification about such frivolous transactions made by you in the name of the firm. In terms of clause 18, my lord, then the arbitral reference was, this is the reference. Then we'll kindly come the next volume, the arbitral award. So on the basis of that reference, my lord, this award has been passed. 110, my lord. My lord, operative part of the award, my lord, kindly come page 163. Paragraph 70 and 71. In view of the award made herein above, there is no reason for the said account of Parambir. Is a firm name, my lord.
Yes.
163, my lord.
Yes.
In view of the award made herein above, there is no reason for the said account of Parambir with Oriental Bank of Commerce to remain frozen. The account was frozen because of fraudulent transactions. Therefore, I direct the senior manager such and such to enable the forum bit to file its statutory return, my lord Kalima. It was defreeze only to enable to file the statutory return. But what happened after defreezing, money has been taken away. In conclusion, I would like to point out that if the case of the claimants was pleaded properly, because of that previous arbitral proceeding was not for the dissolution of the firm, only the reference was on section 21, the clarification of the account. Well, therefore, the firm is there. Then we have kindly come 176. This is the dissolution of the partnership firms. We have issued the notice for dissolution of the partnership firm. This is the whole story has been mentioned. All the facts has been I've stated. Might come 186. Second paragraph, in such view of the matter, there is no.
What are you placing? You just can't randomly place documents. There must be something. What are you placing? 176, then 186.
No, the 176 is the dissolution notice. So I have stated, my lord, the facts, enter fact I have narrated in this notice, why it should be dissolved. So I am showing the prayers, what I prayed in the dissolution notice. I will come at page 186. In such view of the matter, there is no faith, trust, and
Wait, let me first hear Mr. Kothari, his objection, then I will hear.
Just one, I show the reference. Kindly come 191 minute. This is our second reference minute. So since we failed to dissolve the partnership firms, so I invoke the arbitration agreement. I issue the section 21 notice. So this section 21 notice is for the dissolution of the partnership firms. The previous award was made on the basis of the clarification of account. The firm has not been dissolved. Now this issue is left open, whether the firm will be dissolved or not. That should be decided by the tribunal. And the res judicata, question of res judicata order to will not applicable in the arbitral tribunal.
Sorry, I can't understand.
Order to rule 2 will not applicable, my lord, CPC, will not applicable to the arbitral tribunal, my lord. Section 16 is there. If there is an res judicata issue, that will decide by section 16 before the arbitral tribunal, my lord. Also, my lord, one judgment of the Supreme Court, my lord.
Section 11 will not apply.
No, order 7, order to rule 2, section 16 will applicable there on the point of res judicata.
Section 11, I'm asking you.
No, section 11 will applicable, my lord. My lord, that's point I'm showing the judgment of the Supreme Court, my lord. Yes, 2011 3 SCC 507.
On what point?
Well, on the point of res judicata. Because there is a res judicata question, paragraph 16, my lord. I got it, paragraph 16, my lord. Well, the question whether a claim is barred by res judicata does not arise for the consideration in the proceeding under section 11 of the Act. Such an issue will have to be examined by the arbitral tribunal. A decision on res judicata requires consideration for the pleadings and also the claims, issues, points, and the award in the first round of arbitration. In juxtaposition with the pleadings and the issue, points, claims of the second arbitration. The limited scope of section 11 of the Act does not permit such examination of the maintainability or tenability of the claim, either on the facts or in law. It is for the arbitral tribunal to examine and decide whether the claim is barred by res judicata or not. There can be no threshold consideration and rejection of the claim on the ground of res judicata while considering an application under section 11. Because the first round of litigation was only for the clarification of account. The partnership still exists, which have dissolved by notice.
Very well. You tell me when you want to complete your argument. Mr. Pahadi.
Yes.
Yes, when do you want to come back, Mr. Pahari?
Milord Pandey.
Learned counsel appearing for the petitioner who seeks to oppose the contention of the respondent, namely that the application is barred by the principle of res judicata, comma, will continue with his submissions on 13 September 2023.
Your Lordship, I'm seeking one indulgence. Your Lordship, though my affidavit in opposition is ready, it's already been served. Your Lordship, unfortunately, it's not stamped and punched. So, Your Lordship, it cannot be filed. If Your Lordship grants me leave,
He's going to reply, Milord.
Your Lordship, my opposition had been served. They filed their reply. It's not
By 12 PM on Monday.
grateful, Your Lordship.
The affidavit in reply is filed in court today. Stop. Counsel appearing for the respondent submits that the affidavit in opposition is still to be affirmed. Stop. The affidavit in opposition should be filed by 12 PM on 4th September 2023.
Grateful, Your Lordship.
Okay.
Appellate side.
Appellate side daily list contempt matter item number 1.
My application for contempt, my lord. The order under contempt was further assailed by the state government before the Honorable Division Bench. Lord, the matter was remanded by. Sorry.
Okay, finish.
Yes, what are you saying?
But this order was set aside, my lord, by the Honorable Division Bench. May I hand over the copy of the order, my lord?
Yes. Very well. Yes, what do you have to say?
Lord, only one indulgence which we are asking for, my lord. The opposition, the state government already filed the opposition. We have been granted to file my liberty by 18th of August, my lord. We are already out of time. I need further time if the time may be extended to file our reply, my lord.
Yes, yes. So then you have to go to the, this is, nothing remains of the contempt.
My lord.
So you have to go to the regular bench.
Regular bench.
Yes. The learned counsel appearing for the petitioner submits that the order passed by this court on 15th May 2023 in WPA 4149 of 2023 was partially set aside by the division bench on 27th July 2023. Stop. The writ petition was directed to be listed before the court in the week commencing 21st August 2023. Stop. Next. Since nothing further remains in the contempt petition and this court does not have determination to hear the writ petition, comma, the petitioner shall, the matter shall be listed before the appropriate court. Stop. CPAN 972 of 2023 is accordingly disposed of in terms of the above.
Grateful.
Yes.
Item number 2.
Have to appear for the petition in this matter, my lord.
Microphone,
This-
please.
my lord, this is contempt matter for the first time. Lord, the kindly see my lordship's order at page number 16, and operative portion is page number 19.
Yes, the contempt arises out of an order passed by this court on 2nd February 2022. Directing the Directorate of Public Instruction to pay costs of, with a direction, with a, directing the DPI to consider the representation of the petitioners and dispose of the same by way of reasoned order within 4 weeks from the date of the order. Stop. Next. A copy of the list this matter after.
2 weeks in, I shall communicate a copy, subject copy by Monday.
List this matter on 29 September 2023. Service in the meantime.
March of 29. March of
Item number 3.
Number 3, my lord, I beg to appear for the
Can't hear you.
applicant. Lord, I beg to appear for the applicant, Lord, pursuant to my lord's direction on the last occasion, Lord, I am filing the affidavit of exception, Lord, with a copy to my learned friend.
My lord, I am receiving the exception right now, my lord. I have to consider and come back. In the meantime, my lord, we have taken steps and order has been passed in respect of the rest of the building portion, which was not done at that point of time on the last occasion when the matter was taken up. Your lordship kindly considers this. Order has been passed by the concerned authority regarding the unauthorized construction that has been detected in that premises.
Yes. Who has passed this order?
The special officer building has passed the order.
Yes, learned counsel appearing for the respondent, for the alleged contempt now. Files a document showing that the special officer building has passed an order on 10th. What is the date of the order?
My lord, 22nd October 2022, the order has been passed.
22nd October 2022. Stop. She also seeks, counsel also seeks time on the ground that counsel has received, that counsel received the exception only today. Stop. List this matter on 22nd September 2023.
I am obliged, your lordship.
Grateful.
My lord,
File the petition.
item
Wait, let the
item
matter
number
be-
4. Dhan. Hey,
Yes.
My lord, on the last occasion, 4 occasions, my lord, my learned friend is seeking time for one reason to another. For
He's
the,
not sought for any time. So why?
my
are you
lord,
making
in
this
the last occasion, my lord, on 7th.
He's not asked for any time today, so why are you making these submissions? He's here.
My lord, not for today, my lord, earlier with.
Forget about what happened. Make your
My-
submissions.
My lord, today's fixed,
My lord, on the last date, my lord, on 18th August, affidavit of opposition has been directed to be filed, which was not filed, my lord. My lord, today I intend to move the content of application, my lord, on merits, my lord.
Yes.
My lord,
Very
may-
well. I'm recording that affidavit in opposition will not be filed. Yes.
We have already.
I can't hear you.
My lord, we are expecting 1 week time extension, 1 week, only
On
one
costs,
microphone can-
on costs,
My lord, 1 week.
on costs.
My lord,
No, no, no.
My lord, I'm
When-
led by Mr. Shatarup Banerjee. It's
Yes,
his
yes.
instruction, my lord.
You were supposed to file it by 18th August. And yes, there is a delay on the part of the alleged contemners to file their affidavit in opposition, which would be evident from the direction dated 9th August 2023. Stop. The affidavit in opposition was to be filed by 18th August 2023. Stop. Next, the advocate on record of the alleged contemners seeks extension of time to do so. Stop. Next, affidavit in opposition to be filed by 5th September 2023. Stop. List this matter on 8th September 2023.
my lord, may directions may kindly be made as peremptory, my lord.
Next.
Grateful. Thank you.
Item number 5.
Lordship, I'm for the petition, Lordship. Lordship, pursuant to the direction, Lordship's direction, Lordship, I have served a copy of the application to the alleged contemner, Lordship.
When did you serve them?
26th April, Lordship.
26th April.
29th April, Lordship, 2020.
Who is this? Who is the alleged contemner?
DI Balurghat Secondary Education.
Very well. It's now we are in September. Serve them once again and come back. All right?
Lordship,
Yes,
Lordship,
the
kindly
affidavit of
record,
service
Lordship, I have served
shows that the alleged contemners were served on 29th, was served with the order passed by this court on 21st April 2023. The affidavit of service shows that the alleged contemners were served with the order passed by this court on 21st April 2023. Stop. Next, since substantial time has passed since then, list this matter on 22nd September 2023. Service, this order shall be communicated on the alleged contemner.
Lordship.
Item number 6.
My lord, I am for the petitioner, my lord, led by Mr. Shukdev Sarkar. My lord, on the last occasion.
Led by?
Mr. Shukdev Sarkar.
Yes.
My lord, on the last occasion, your lordship has directed, your lordship has passed an order, my lord, directing the respondent number 2 and 3 to furnish the information, my lord. My lord, this is the first time, my lord, this contempt application we have filed, my lord.
Yes, adjournment is prayed for on behalf of the petitioner. List this matter on 22nd September 2023. Next.
Item number 7.
This is a contempt petition where where my lord's order, which is at page 235, had two parts. One is to pay the sanctioned amount, already sanctioned, disburse it. But before that, give an hearing for the balance amount. Now, so that within 4 weeks of disposing of my representation, they will disburse, within 4 weeks. So they are going to disburse this already sanctioned amount and also any more amount that they are supposed to earn. Kindly see my lord's last day's order, which is a page, which is the 22nd September 2022. So, very well, Lordship. Oh, 22nd September. Oh, this is the order. Where is the contempt order? Where is the order which she passed?
22nd September.
No, my lord, that's the order in contempt. That is page 235.
I've seen that.
Now, Lordship, my lord's further order.
235 or 243?
245, 236. 243 also. Same order has been annexed twice, my lord.
Yes, I've seen that. Yes.
Which page? Now, in contempt, Lordship, when hearing the contempt, Lordship passed an order on 7th August 23. Before that, where is the order? We have done the correction.
Mr. Banerjee, you're appearing for?
I'm appearing for the respondent number 1, my lord. I represent WBIDC, my lord. Respondent number 1 is both, my lord, the principal secretary as well as the managing director of WBIDC. In the writ, I represented WBIDC, my lord. But this is the order, my lord, passed in terms of your lordship's, my lord, direction on 7th of August.
You have passed an order.
An order has been passed, my lord. But it has been held that he's not entitled to any further amount. Passed by
Mr. Mitra challenges.
Lordship, there's two parts. Lordship, kindly sees my lord's order in contempt 15th May. 15th May.
That's 22nd September.
22nd September, Lordship, kindly sees the second page of the order.
Yes.
22nd September, the second page of the, keep this open.
No, where are you
That's-
getting 15 May from?
That's in contempt, that's in contempt. Lordship, before that, the 22nd September, page 2, first paragraph. Upon considering the documents referred to above, it appears that despite the letters of sanction given in January and April, WBIDC as well as the state have not taken any steps for disbursement. That's one part. WPA is disposed of with the direction on the WBIDC as well as Secretary Finance to dispose of the representation made within 6 weeks. The state, now the second part, the state shall disburse the amounts already sanctioned to the petitioner in terms of the letters of WBIDC within 4 weeks from date on which from 4 weeks from the date on which representation is disposed of. That is the two letters of January and April, page
That's all
227.
right, but they are saying they've already passed an order.
Now, Lordship, after passing this, after the contemplation was filed, they have passed an order on the representation. But so far as the sanctioned amount, they have 4 weeks to pay, which they have to pay from the date on which the representation is disposed of. Lordship kindly takes a look at the order which I just now showed, and also 15th May, Lordship has captured this in the contempt, 15th May 23.
Yes.
The first paragraph, fourth, fifth line, the alleged violation relates to an order passed by this court of 22nd September by which WBIDC, Ministry of Finance, were directed to dispose of the representation made on 14 November within 6 weeks from date. The state was also directed to disburse the amounts that were already sanctioned to the petitioner in terms of the letters issued by the WBIDC within 4 weeks from the date on which representation is disposed of. That already sanctioned. Now, what is doubly contumacious is, while disposing of the representation, they have also said that they will not disburse the amounts already sanctioned. That part is a further content for which I prepared a supplementary affidavit bringing this on record. They have 4 weeks time from now to disburse the amount already sanctioned, which I will show, which were annexed to Lordship. May serve them. We have served them a copy, Lordship. This is part of the. I had a copy. Lordship, this was the letters referred to in the order of 22nd September at page 227. Kindly come to page 227.
No, Mr. Banerjee, what do you have to say to that?
Lord, in my humble submission, payment disbursal is dependent on the disposal of the representation. First. Secondly, my lord, WBIDC had not issued some letters of sanction, but not the principal secretary, who is a higher authority, has come to a finding based on the scheme after hearing the parties that these amounts are not to be paid because the financial cap is there, and on the basis of there's a yearly cap, we cannot sanction any amount above that cap. These findings are there in this order. Now, this is not what I gather from the order passed.
Mr. Banerjee, there were two parts.
My lord.
to the direction at page 244. One is to consider the petitioner's representation within 6 weeks. And second part was, if you come to 244, the state shall disburse the amounts already sanctioned to the petitioner in terms of these, in the terms of the letters. All right, what are where are these letters?
27, or should kindly see page 227 and 228.
Yes.
The 227 letter says in no uncertain terms, the fourth line, we would like to inform you that this corporation has admitted 16 crores only and 21 for the financial years 10, 11 and 11, 12. On the following terms and conditions will be disbursed. I am willing to comply, Lordship. And then 228 also. So that's why Lordship referred to the January and April letter. 228. The fourth line, we would like to inform you that this corporation has admitted 28 crores. Only I pay for 1230 on the following term.
Yes.
Add
So,
further
so,
amount.
so that was the second.
Second part, may
So when you say that you have already, sorry, Ms. Banerjee, when you say that you've already passed an order, that is something which will go to the appropriate court, and it is for the petitioner if the petitioner challenges that order. But with respect to the contempt, the second part has not been done. You cannot say that we have passed an order, therefore it depends on the eligibility or whatever you want to say. That is something before the appropriate court.
Disbursal is not dependent on the disposal of the representation. That is the point. May I get a week's time to respond to this? State is also supposed to be present. I don't know why they are not present. Should have been present before Lordship, because we are not only the paying authority.
Because if the second part had not been there, then you could have said that yes, we dispose of the representation. We took a conscious decision that they are not eligible for the money, for the funds, whatever the loan, then we did not give them. Fine. That is up to you and up to Mr. Mitro to take it to the appropriate court. Yes. The contempt, I've already passed orders. Why do you want to
bring
file?
this order? Because this, after all, this is handed up in court, but I want to keep this on record officially, because where they have said that I've been
Handed up in court. So how did you know that they will hand up something? We already got something ready.
Yes, because we have been served with the order where they have said I will not pay even the sanctioned amount. That's why we had brought this on
No,
record.
I thought Mr. Banerjee wasn't aware. You're going to tell Mr. Banerjee that such an order has been passed. That's not the case.
That's very often the case, but then today he seems to be also.
Yes. Learned counsel appearing for the WBIDC. Learned counsel appearing for the alleged contempt of
Number 1.
alleged contempt of number 1 seeks time to take instructions in the matter. Stop list this matter on 8th September 2023.
May I keep the supplementary on record?
Yes, the petitioner's supplementary affidavit is taken on board.
Deep Lordship.
Hold on. And the affidavit is served.
Item number 8.
Item number 8, I'm for the petitioner. It's a new contempt, the order is at page 10, dated 16 September 2022. The operating portion is at page 11, third paragraph.
The contempt arises out of an order passed by this court on 16th September 2022. Stop. List this matter on 6th October 2023. Service in the meantime.
Item number 9.
And I am for the petitioner. Your Lordship's order. Annexed at page 17. Operating part is.
I can't hear you.
Operating part is 25 lower portion. The court is therefore of the view.
I can't hear you. Microphone, please.
The court,
Where, which I
page
could
to
not,
page 25 operating portion, lower portion. The court is therefore of the view that WPA 25206 may be disposed of with a direction on the Director of Public Instruction to consider and dispose of the representation of the writ petition in terms of the benefits paid for by passing a reason order upon considering all relevant memoranda and notifications which have been relied upon by the petitioner. The reason order should be passed within a period of 6 weeks from the date of communication of this order as suggested, and a copy of the same shall be given to the petitioner within a week thereafter. On the next page, we have obtained the certified copy of the order in the month of February and served them on 28/2/2022. Order dated 16/12/2021 passed by Honorable Justice MOUSHUMI BHATTACHARYA and enclosed hearing. Next page. Petitioner received one communication.
very well, first time,
This first time.
yes.
My lord, I
On
have
20
instructed to appear in this matter, my lord, on behalf of the alleged contemner. Copy has not been served.
Naturally,
My lord,
yes.
And my lord, in page 29, first line, while disposing the case, the Honorable Justice Amrita Sena held as follows. Immediately I don't know how His Lordship Amrita Sena come here in the speaking order. And immediately we communicate them. Yeah, we have not communicated any order of Amrita Sena. We have served you the certificate copy of the order of the Honorable Justice MOUSHUMI BHATTACHARYA. And immediately thereafter also after 1 month we filed first contempt notice, second contempt notice, but they have done nothing. They have not passed any order following your lordship's order. As they appeared, I can serve immediately there. We have extra copy.
Very well. The contempt arises out of an order passed by this court on 16 December 2021. Stop, list this matter. On 8th September 2022. No, on 22nd September 2022. Stop. Next, Mr. Who you are?
Tapas Kumar De.
Mr. Taposh Kumar De, who is present in court, seeks to represent the alleged contemnors. Stop. Have you given him already?
Yeah,
A copy of the contempt application has been handed over to Mr. De in court today.
Which will hand over.
Item number 10.
Your lordship was pleased to pass an order, page 23, November
I
20,
can't hear you. Yes.
November 28, 2022. To decide the proposal of the petitioner within 2
Give me the
weeks.
page number.
Page 23. But it was not complied with. Then contempt notice was given. Then, my lord, in month of January, we are called. They prepared minutes. And we objected that you have been asked to decide our claim. We are ready to pay entire 90 lakhs at a time. Then, my lord, kindly last page, page 38. You are at liberty to approach us with concrete settlement. Every time we are ready and willing to.
Yes, the pagination of the petition is required to be corrected. Stop. List this matter on 22nd September 2023. Next.
Kindly grant leave us to correct it.
Yes, the petitioner's advocate on record is given leave to take necessary steps. Next.
Item number 11.
I appear for the petitioner's lordship, which my affidavit of service may be kept on record. Lordship, may I also indicate the respondent.
I can't hear you.
Lordship, the respondent numbers 3 and 4 could not be served, Lordship. It has come back as a dressy change.
Respondent or
Lordship.
alleged contemnors.
I'm sorry, Lordship, the alleged contemnors number 3 and 4, Lordship. 1 and 2 is being served.
Yes, so what is it that you want?
Lordship, this is my contempt application arising out of your lordship's order dated 22nd September 2020.
Have you served all the?
Served, Lordship, 1 and 2 are.
Yes.
Yes.
I'm appearing, my lord. The order has been complied with. This is the order has been passed.
by the alleged contemner number 1.
One. So
One.
that's the only alleged contemner.
No, my lord, there are 4 alleged contemners. 1 and 2 are represented.
So have you served a copy on them?
Yes, my lord, we have.
Uh.
3 and 4 could not be served.
Have you served a copy of this order on?
Yes,
can't you
lordship.
understand?
Yes, lordship, we have.
Yes, so what do you have to say?
Lordship had passed an order directing the principal land and land reforms to consider and dispose of my representation dated.
So they have done this?
Yes, my lord.
Yes.
Lordship, my contention is that, lordship, in terms of the representation, they were to consider my entire representation, but what they have really done is, my lord, they've returned a piecemeal finding and they've restricted their finding to only one particular moja, lordship, that is 3113. Lordship, I am the owner of 4,700 bighas of land.
No, is that correct, Mr. Dhor? Only one has been done.
Whatever was in the representation, we have considered that and we have disposed of.
Very well, file a report to that effect.
Wonderful.
Then yes. Their learned counsel appearing for the alleged contemnor number 1 submits that the order in contempt, namely passed on 26 September 2022 has already been complied with, and that the alleged contemnor number 1 has passed an order on 12 December 2022.
No.
Oh,
Lord, not 12th
The order
December,
is dated
perhaps.
7th of February
No, no, that
2023.
is,
Where do I get that date?
Lordship, page number 113, lordship.
113, then what have you handed up now to me? How can it be 113? You handed up something today, just now.
no. That was the order passed by the Land Reforms Commissioner,
That is
Principal
what I'm
Secretary.
saying. What is the date
Kindly-
in this?
That is 20th January 2022.
Yes, but the 2 pages give 2 different dates.
My lord, the final order is dated 7th of February 2023.
Yes.
There
Where
were
is that?
hearings held on several dates, lordship.
Where
The
is
final
that?
order was passed on 7th February 2023.
Would you find-
Yes, learned counsel appearing for the alleged contemnor does not appear to be ready to argue the matter and has handed up an order to the court, which is not the final order, which admittedly is not the final order. Stop. List this matter on 8th September 2023. Counsel is expected to be ready on the returnable date.
I'm grateful, lordship.
Next, don't waste the court's time. Next. As it is the one which you hand up, it doesn't even show the date. 2 different dates on 2 different pages.
I'm
Next.
grateful.
Item number 12.
I'm praying for issuance of a rule.
The petition appearing for the respondent municipality, my lord.
Please,
I can't understand what you're saying.
We have not received the money.
I can't understand what you're saying. Yes.
may I explain the matter, my lord? If your lordship is pleased to take page 112 of the petition. We had, my lord, supplied LED street light fittings to the municipality. Your lordship's direction was that the state authorities, that their defense in the writ petition was that we haven't received the money from the state. so
Where
we
is the
can't-
order in contempt?
my lord, page 112
Yes.
of the contempt petition.
Yes.
My
What
lord,
was the direction?
The direction was that the state authorities, being the respondent numbers 2 and 3, are directed to
Who is
disburse.
2 and 3?
2 and 3, my lord, is the state joint secretary and commissioner of the Department of Urban Development.
Yes.
They should disburse certain amount to the petitioner within 10 weeks, and the order should be communicated to them, which was done. And the municipality is required to disburse thereafter to the petitioner, and they should disburse to the municipality. Now, municipality is here and says, which we always suspected, that they have not received the money from the state. So, my lord, we are today, my lord, in an endless pursuit of the money.
Yes.
So we filed the contempt petition. We've served the municipality because they appeared. Appeal has also been filed by the municipality. No, by the state, I'm sorry, by the state.
Yes.
But there's no order of stay. That's not been pending for a long time. They have now stopped appearing.
So
before your
3 crores,
lordship.
66 lakhs they were supposed to give you.
Yes.
And
But the contempt petitions
and
appear.
this is the first time it's appeared.
No, it's appeared a few times. They've never appeared.
my learned friend was not well, which is why my learned friend's junior had come and obtained adjournments. We had not opposed. He was hospitalized. They went below 2 months. And state is singularly not.
And alleged contempt on number 4 is who?
4 is the chairman of the municipality.
I'm appearing for the chairman of the meeting.
I'm not asking for, my lord, a rule to be issued against the municipality, having regard to their stand that they haven't received the money. If they had received the money, then I would have asked for a rule.
Yes, where do you find out that they have stated this, that they have received the money
And
from
my
the state?
learned friend submits today that the municipality has not received any money.
Is that correct?
Yes.
Microphone. Microphone.
Yes.
Very well. Yes, the contempt arises out of an order passed by this court on 23rd November 2022 on a writ petition containing a claim made by the petitioner on the Bhattacharya municipality for supply of LED street light fittings. Stop. The writ petition was disposed of with a direction on the Joint Secretary and Commissioner, Department of Urban Development, within brackets, respondent numbers 2 and 3 in the writ petition, close brackets, to pay an amount of rupees 3,66,04735, page 114, to the petitioner within 10 weeks from the date of communication of this order, or of the order. Stop. The order was communicated on the alleged contemnors on?
It's not on
the respondent numbers 2 and 3 on?
On Millard 2 and 3, 2 Millard on 28th November 22, 3 on 25th November 22, and 4 Millard refused service.
On the respondent numbers 2 and 3 on 28th and 25th November 2022, stop. The fourth respondent apparently, allegedly refused, the fourth respondent refused service. Stop. Next, the contempt petition was heard at least on 3 occasions when only the alleged contemnor number 4 was represented, namely the chairman of the Bhattacharya municipality. Stop. The alleged contemnor numbers 1, 2, and 3.
We've not served them though. We've not served them. Millard.
The alleged then how will they know?
No, they're not supposed to. Millard. No, I wanted to come and pray for a rule. Millard, the state has filed an appeal. I have an order, Millard, which says that they haven't, Millard, appeared in the appeal also.
Very well. The court is informed that the state respondents have challenged the order dated
23rd November
23rd November 2022, but have not taken any steps to move the appeal. Stop. The an order passed by the division bench on 6th July 2023 corroborates the aforesaid. Stop. What happened on 20th July?
No, it wasn't called on. I don't think it's ever been called on.
Stop. Next. The state hence knows very the state hence is fully aware of the order and the directions passed by this court, but have stayed away from the contempt proceedings on the last 3 occasions. Stop. Next. The submission made on behalf of the alleged contemnor number 4, represented by learned counsel, is taken on, is noted, semicolon, namely that the Bhattacharya municipality has not received any money from the state, and hence the order passed by this, and hence the municipality could not comply with the directions of the order in contempt. Stop. Next, the contempt was filed on, what is the date? What kind of handwriting is this? Look at page 16. What is this?
I'm sorry, Milord.
Is it 19th?
19th April 2023.
That's 19th.
It's a peculiar way
19th
of-
in a cursive. Yes.
peculiar way of
Yes.
writing.
The contempt application was filed on 19th April 2023. And the state / alleged contemnor numbers 1-3 are still to come before the court. But you have not served them, so I can't write this, Mr. Chaudhary.
I'm entitled to issuance of a rule without service if there's complete breach.
Yes.
I would only request for a rule against contender numbers 2 and 3. They are the joint secretary and the commissioner. The principal secretary, my lord, is really too high up for this. But he is not supposed to, my lord, do this also.
Very well. Ki bolam last?
Directions were also against 2 and 3. 1 my lord,
19th April 2023. Stop, even though, but the non-compliance of the order dated, the contempt application, the non-compliance of the order in contempt continues for more than 8 months, continues for more than 8 months. Stop. Next, this is hence a fit case for issuance of a rule against the alleged contemnor numbers 2 and 3, who were made fully aware of the order passed by this court. Stop. Next, we rule issue jeta ache ota diye daw, বুঝতে পেরেছো তো এই ফর্মটা দিয়ে দাও। Read it. The rule is made returnable on?
Not 6 weeks.
The rule is made returnable after 6 weeks. 6 weeks hence. After the 6 weeks hence. Okay. List this matter on.
No, because department draws up and
Yes,
sends, it
yes,
takes a little bit of time.
Yes, is returnable after 6 weeks, after 6 weeks on. October 2023.
Grateful.
Next. What is Can 1?
So that can be filed here. I'm
Has
sorry,
to be
Lord.
before the writ court.
This is the content. Oh, yes. Sir, I thought that was filed in the contempt petition. Now this is execution application.
Yes. The Can 1 of 2023 must go before the court having determination and is hence released from this list, from my list.
Grateful.
আচ্ছা ওটা এখানে রাখো, আমি পরে দিচ্ছি। Item number 13.
My Lord, I'm appearing for the petition led by Mr. Oyan Banerjee. This contempt application is appearing for the first time. It's against the non-compliance of your lordship's order dated 15th of November 2022. The order
Give the
is at page
page.
36, your lordship. The operative portions are page 37, if I may place it, your lordship. WPA 12168 of 2022 is disposed of with a direction on the petitioners to submit the GST compensation claim as instructed in the letter of the respondent number 2 dated 15 July 2022 in accordance with the form given to the petitioners within a period of 10 days from today. The respondent number 2 shall process the
Very good.
request.
Yes, the contempt arises out of an order dated 15th November 2022, by which the writ petition was disposed of by a direction on the
Respondent number 2 is West.
respondent number 2 being the
Respondent number 2 is the agency, Your Lordship. The alleged contemners are functionaries of the agency. The respondent number 2 in the writ petition was the West Bengal State Rural Development Agency. And
yes,
the-
respondent number 2, namely the West Bengal State Rural Development Agency, to process the petitioner's request for refund within 4 weeks from the date of receiving the claim and disbursing the same to the petitioners within 8 weeks from the date on which the respondent number 2 receives the claim from the petitioners. Stop. Next, list this matter on 6th October 2023, service in the meantime.
Deeply obliged, Your Lordship.
Item number 14, my lord, we beg to appear on behalf of the alleged contempt.
Yes.
My lord, I appear for the petition, my lord. Service has been done. Your lordships, the violations has been alleged of your lordships order dated 3rd May 2023. Order starts at page 52.
Now, what is the violation? This
Lord, virtually the persons, my lord, whose tender was rejected by your lordships, saying that he had submitted the certain documents, my lord, your lordship will recollect, my lord, this is a ESI matter.
No, I will not hear it in detail today. Just tell me what.
Yes, my lord, now the same person, my lord, the document which was rejected by this court, my lord, the authority had again reiterated the same documents and continue, my lord, permitted him to continue.
Very well. What do you want to do, Mr. Mitra?
My lord, if your lordship kindly takes your lordship's order, my lord, at page 56 of the contempt application,
Yes.
at page at para 11, that is the operative part. There are 3 parts of your lordship's order, my lord. First, my lord, has your lordship got it, my lord? Page 56, para 11, my lord.
Yes.
My lord, second line, my lord, 3 parts of your lordship's order, my lord, to revisit the evaluation of the financial bids submitted by the bidders, including the petitioners, and arrive at a fresh decision within a fortnight from date. And third part, my lord, needless to say, the fresh evaluation will be made strictly in accordance with the terms of the tender and documentation relied upon by the parties before this court. My lord, these are the, my lord, directions of your lordship which have been strictly complied with. If your lordship kindly takes page 65 of the contempt application, your lordship would find these are, my lord, the reasoned order after evaluation, my lord, fresh decision has been arrived at.
Mr. Bandyopadhyay, go before the writ court.
My lord,
The
kindly
scope is
take
very
only
limited,
one
my lord.
paragraph. My lord, kindly come to page
No, I will not
55.
hear it today. I'm telling you, go before the writ
My lord,
court.
kindly come to page 58, my lord, 55, kindly.
Yes.
My lord, your lordship will find that they have given a, my lord, justifications of the rate violators dated, my lord, 20. Kindly take page 56, paragraph 9.
Yes.
The above findings is reinforced by Corrigan file. It is evident that the SI authority Sirampur has made a departure from the hospital Bajbaj and there is no basis for disclosed making departures. My lord, kindly take, my lord, just, my lord, paragraph 7, page 55.
No, I'm not hearing all.
My
this
lord,
today.
paragraph 7. My lord,
No,
kindly.
come back on some other day. No.
My lord, it's a
I-
gross violations of your lordship's
Very-
order.
very well.
But your
Yes,
lordship virtually rejected their tender, but the same document
no,
was
no.
relied on.
Your lordship.
But I can demonstrate it, my lord, 2 minutes. My lord,
it is,
kindly
no.
take,
It is,
my lord,
it
kindly
is-
take, my lord, once, my
If
lord.
you shout, I will release it.
My lord, no, I'm just shouting, my lord. My lord, it is a gross
Not in my
violation.
court, please.
My lord, it's a gross violations, my lord,
Yes,
of your lordship.
it is
My lord, they have
arguable,
taken for
it is
granted.
arguable whether the order passed by the alleged contemners is in violation of the order passed, of the order in contempt. Stop. Prima facie, comma, the order is a fresh, the order gives a fresh cause of action to the petitioner to go
My lord,
before the
I can,
appropriate court.
I can come back, my lord. Your lordship, kindly hear me for a moment, my lord. I can show from your
The
lordship
last
document.
data Kirada, list this matter on 22nd September 2023.
Yes, my lord, I'll demonstrate, my lord, how it has been violated. My lord, they have taken the court for granted, my lord. Well, I'm sorry, my lord.